With note.
Some new motion.
My lord, I am seeking a leave, my lord.
New motion.
Court number 17 is.
What is the urgency?
My lord, the IIB exam is held on 30th, my lord. I am appearing on that. First, they have criteria for graduate. I need a scribe. They have graduate for, they have allowed for a graduate person. But yesterday, they have sent me a mail.
Give me a minute. Our determination আছে। Justice Basu's determination.
Yes.
Is it appearing in the list?
No, my lord. I have to file. I have affirm and everything has been done, my lord. I have to serve the copy and I can.
Then it will appear tomorrow.
Yeah, yes, my lord.
All right. Leave to file to appear tomorrow.
Lordship may be permitted.
Yes.
My lord, may be permitted to mention these three analogous writ matters. My lord, this is a land closure matters and
Under what heading?
under group one. Under group one.
Hearing or motion?
It's in motion, but my lord, I have the instruction from the petitioner to withdraw this matter.
Withdraw?
Yes, my lord.
All right, to
Sir, may I be? Lordship, the petition. I'm for the petitioner. The urgent matter is that the public sector undertaking company have forcefully acquired the petitioner's land and started the illegal installation of the pipelines, despite without any prior notice. And
stage or hearing?
it's a hearing. It's a fresh matter.
Please wait.
Sir,
Yes.
may be permitted to mention, my lord, the matter relates
Sir,
to
it's
the
a fresh
land.
matter motion. It's a motion, fresh matter.
Motion?
Yes, sir.
The matter relates to the land acquisition by the West Bengal Power Development Corporation, my lord.
Motion or hearing?
But it was appearing under the heading to be mentioned motion matter, my lord. There was a direction
Mention it was appearing.
for some urgency for previous mentioning, my lord. It was initially the substitution was allowed and yes. And my lord, 31st October there was a direction by the previous coordinate bench it will appear, but it hasn't appeared. My lord. That is the urgency.
Yes, Mr. Bhattacharya.
Three matters, pertaining to the determination of Justice Basu. I want to move it.
What is the urgency, Mr.
There is grave urgency. It concerns students, who intend to appear in examinations.
When the examination will be held?
The date will be, declared any day. They have not been registered.
There will be some gap, Mr. Bhattacharya. It's only for one day.
May I?
Examination is only for one day.
And the two other matters, pertain to MSc nursing students, they are unable to upload their research papers, in the system, despite there being a clear interim order, this honorable court intended their instructions.
Bhattacharya, is it that urgent you cannot wait for one day? It's only for one day.
As you know.
Like extension of interim order on the original side, my lord. I'm enjoying an order of
Group 1.
Group 1 landmark.
Your lordship may be permitted to mention one review application. I have earlier several times have mentioned for inclusion in the list, and the learned court below has asked for stay. Yes, my lord. Stay order unless they will vacate and proceed further for argument stage. On 16th of December is the next date. My lord, kindly consider it an inclusion in the list. The order is incorporated there.
কালকে দিয়ে দিন তো
Grateful, your
yes, contempt.
It's running in your lordship's list as item number 92 and 94
of the monthly list.
Of the monthly list.
92
and 93.
Please keep a watch on the list next week.
No.
Yes. It's not that urgency that you have to move it prior to the next
difficulty is, my lord, they lost in
for 1 week.
Yes.
That is why. Please keep a watch on the list. Yes.
My lord, in item number 1, I am appearing for the writ petitioner. My lord, I intend to withdraw the writ petition, my lord.
Written instructions you have got.
Yes.
Where is the written instruction?
Order তুমি দাঁড়িয়ে
This is the yesterday's matter, my lord.
কোনটা?
My lord, in yesterday's matter, my lord, we had undertaken to withdraw the writ petition, my lord.
The learned advocate.
Section 34 of the Arbitration Act, my lord.
Where is Mr. Banerjee?
My junior is
My lord, I'm his junior manager in this matter.
He's in court number 6.
Oh, you are assisting Mr. Banerjee, Mr. Owen Banerjee?
Yes, my lord.
Oh, and where is the Mr. Rudrajyoti Bhattacharjee, Union of India?
yes, my lord. I served notice to both of them, my lord.
This railways. So Union of India is the effective.
My lord, I also served notice to him, my lord.
Sir, who is appearing? Please ask
Mr.
him.
Rudrajyoti
Because
Bhattacharjee.
his absence, Mr.
Then can you
Bari-
make it not today, my lord? I again serve notice to my lord, the learned advocate, my lord.
When the award was communicated to you?
My lord, award passed on 12th June. My lord, I received it on the month of July. My lord, I filed the writ application in the month of August.
We filed it in the month of August.
Yes, ma'am.
So
13th August, I
can
filed
you
this.
come at 2 p.m.? Can you bring him it?
I shall try. I shall try.
At 2 p.m. Yes, next.
My lord, in this matter, my lord, I am led by Mr. Saptangshu Basu and Owen Banerjee, my lord. You are kind enough to make it one day accommodation, my lord. It is an extension of interim order. Your lordship of earlier occasion, my junior moved. Your lordship says that the call Mr. Basu to whether there is any scope for interim order.
No, call Mr. Basu. She was here. You can move.
No, my lord, I mean, it's a hearing matter. Hearing matter, my lord. Hearing matter, my lord. Kindly, my lord, one day accommodation, Mr.
Not
Basu.
hearing, for extension of interim order.
My lord,
Whether you have a case for extension of interim order, that will be only considered,
my lord,
not the entire hearing.
my lord, that is my lord, one day accommodation.
Where is Mr. Basu? Where is Mr. Banerjee?
Mr. Banerjee's courtroom number 6. my lord.
Passing it over, ask them to come. Pass over, yes.
My lord, interim order last extended on 24th November 2025.
My lord, your lordship, very short matter, my lord. I have already filed the affidavit of opposition and reply was there. My lord, very short matter. Not only your lordship can.
What is this matter?
More matter.
Let the matter be extended first to interim order.
So that's not a matter of right. What is the matter? You have to satisfy that there is a case for extension.
Because it was
not
last.
Mechanical, sir, extension of interim order.
My lord, it was last extended on.
Sir, what's the matter?
Minor Minerals Act. It was a long-term mining lease which was executed by and between the parties, and it was renewal was submitted before the new rule, that is 24/9/2021, before the notification.
What is the order which you are challenging?
I'm challenging the renewal should be passed in favor of the petitioner, because and all the requisite compliance was done in accordance with law. And learned coordinate bench already passed an order, Justice Vivek Chaudhary. The better it kindly fix the matter for hearing.
Are you ready today for hearing?
No, sir, I am not ready.
The learned friend is praying for taking up for hearing.
Yes, my lord, as because very short matter, as because order was passed according
You
to
are
the
ready,
provision,
or if you are not ready, I can take it up tomorrow. He is pressing for hearing, so you have to satisfy that there is a ground for extension. It's not mechanical. Or you can come tomorrow, because he is pressing for hearing of this matter.
Kindly, my lord, it was last let me submit.
Sir, you are not following. If you have any problem with the main matter is disposed of.
No, okay, then my lord. Can we fix on day after tomorrow?
Yes. Day after tomorrow. On the prayer of the learned advocate for the petitioner, list this matter.
Been passed over, may I
Yes,
make the
yes, Mr.
same prayer?
Banerjee.
May I make the same prayer for the your lordship wanted to hear the matter, but we are ready with the matter. Mr. Basu is appearing.
Extension of interim order. Here it's here they have not paid for hearing of the main matter. Extension
yesterday
of
when the
interim
matter
order,
was taken
Mr.
up-
Banerjee, please satisfy me where is the case made out for extension of interim order.
No, yesterday the matter was taken up. Your lordship wanted to hear the main matter. Mr. Basu is appearing.
Please satisfy me that you have any ground for extension of
Ground
interim
for extension, my lord. Kindly
order.
see.
I find, Mr. Banerjee, there is no
Matter is, my lord. I'll indicate, my lord, what is the matter, my lord. Sand mining lease was granted.
Already want Mr. Basu's presence, I can adjourn. it.
Kindly take up day after tomorrow, my lord. Day after tomorrow.
On the prayer of Mr.
appearing on behalf of the petitioner.
I am for the private respondent.
Since I am not inclined to take up this matter on personal ground, this matter stands released from the list of
Yes, there, my lord. I was doing matter at code number 4, my lord. Copy,
4. All right, give your appeal.
yes, my lord. I am also.
He's assisting you.
No, I have given you your name also.
Yes, yes, next. Please give the appearances. Yes. On the next matter.
Lokinath Bhattacharya.
Petitioner lordship has wrongly filed in your court lordship. It is a group 9 matters lordship. Kindly release. Yes, lordship. It's a inadvertently.
Advocate appearing for the petitioner submits that through yes.
Malad, page 46, Malad, compensation already been ordered against the petitioner, in favor of the petitioner. In earlier occasion, writ application has been filed. Page 46, the order has been passed. And there was a direction within 30 days, Malad, entire proceedings must be completed by the authority concerned. And till today, Malad, they did not made any compensation in favor of
The
me.
compensation has been paid. You started
No.
saying.
No, Malad, compensation has not been paid. For that reason, writ application has been filed. Page 46 is the order passed by the Honorable High Court in the year 2010.
What were you doing so long?
Malad, after that, Malad,
Yes.
the aged person, Malad, in several occasions made representation before the authority concerned.
Yes, Mr.
Malad,
Bandyopadhyay.
today, Malad, the petitioner is 7.
Award.
My lord, like CSC is the, my lord, the recorded owner. The land has been acquired in favor.
Maybe Mr. Bandyopadhyay, the plot was acquired. Have you published an award?
My lord, he has not, my lord, stated before your lordship all the relevant facts, my lord.
What are the relevant facts?
My lord, your lordship kindly turn to page 33.
33, yes.
I don't know what happens thereafter. With reference to the above, this is to inform that the measuring such and such acres of plot number 1, that is the plot in question. Moja such and such, jail number 40, PS Bajbaj, district such and such has been
Final award was declared
declared, but not paid.
due to a de-requisition proposal of the said plot. What happened?
Thereafter, my lord, I don't know, my lord, whatever. However, the de-requisition proposal.
But then please file a report.
Finalist, yes, my lord.
File a report because there is a
Otherwise, it
proposal,
cannot be said, my lord.
yes, proposal for de-requisition. And where is the earlier order?
My lord, page 46, considering all those things, my lord, 46 order has been passed. Page 46, order has been
That
passed.
this document was considered.
Yes, ma'am, that was part of the writ.
Madam, maybe you have annexed many documents. You have not placed this document when you have moved. Since Mr. Bandyopadhyay has drawn the attention of the court, I came to know of this.
These documents.
Nobody knows. Please show me from the order passed at page 46. This matter was taken note of. This fact was not taken note of.
Page 33, 2001.
Submission that
Page
they have
30,
refused to.
page 33, 2001, my lord.
Yes, yes.
And my lord, order has been passed, page 46.
Yes.
My lord, considering all those things, my lord, there are.
I know. Please show me from the order that it was considered. Show me the reflection of that memo in the order.
That has not been, my lord.
Maybe in the writ petition you have annexed 100
That
documents.
has not been considered.
But if you have not pressed that point, so you have abandoned that point. That's the law.
My lord, if de-requisition proceedings has been started, my lord, then what is the fate of now, my lord, this is the position, my lord.
That's not your prayer, madam.
My lord,
that's not your prayer
in the earlier.
You have annexed this document.
Yes.
But you have not stated with regard
My
to
lord, kindly see the issue involved in this writ application are similar to the issue such and such, disposed of by this court by an order
why
that.
you have waited for 15 years, madam. Your
My
client
lord, that
knows
is,
what happened.
my lord, 74 years, my lord.
Your client knows he was not 74 at that point of time.
And now.
Then
Yes.
maybe 74 now.
Yes, yes.
At that point of time, she was not 74.
Yes.
So that might be one of the reasons for this delay.
My lord,
She knows what happened.
My lord, this was not intimated anything after passing of this order. My lord,
You have
nothing.
also not taken steps. You sat tight for 15
Nothing.
years.
A contempt application has been filed that was not traceable. My lord, after that, my lord, now when.
Mr. Bandyopadhyay file a report. When?
2 weeks time, 2
weeks.
2 weeks or 3 weeks, my lord, as you love.
2 weeks, let it be.
I shall try. I shall try.
Either made
yes, my lord, I shall try.
My lord, every service.
Every service filed in court today is taken.
'21, my lord, onwards. 399 Khotiyan number, Sabek Dapunabad. Page 21.
399.
399 and 890.
These are the two plots.
No, my lord. Another plot are there. And page 23. Habek dag number 2. Dag number 4. Nipendranath Karan and Jabarani Karok. And my lord, page
So
24.
plot numbers 2 and 3 are the subject matter.
4 also. That is page 24.
Plot number 1.
Plot number 1.
1 is the subject matter.
No, my lord,
One
several
was
plot.
only acquired.
Several plot.
Well, he has stated in paragraph number 2. Plot number 1.
No, my lord.
That is the recorded possession of plot number 1. Stated in paragraph number 2.
My lord, that is.
Now, are the recorded owners of plot dag number 25, Elat dag number 4, Elat dag number 2, Elat dag number 4 and 5.
Yes. My lord, that is 20.
Which was acquired according to you?
My lord, all the plot accord.
Show me the notification.
Notification is my page 24.
Yes. No, 24 is the record of rights.
28, sorry, my lord, 28. 28 onwards. My lord, that is page 31. Description of the land. Jail number 42.
This is which Mouja?
My lord, Pujali.
Pujali, yes.
Pujali, no, to me.
42.
Moja Rajarampur.
No, my that was.
In paragraph 2, my lord,
Just stated Rajarampur.
My lord, that is. Mouja Rajarampur. My lord, I am showing.
Mouja Rajarampur.
Page 28, Milord.
My lord, that is my lord, second para. My lord, I am sorry. Page 28, second para.
Rajarampur.
RS plot number 1 to 10.
My lord, this portion.
21 to 25, it was entirely acquired.
Milord, these
plot numbers, and 21 to 25, the writ petitioner claims RS dag number 22, 6 and 4. Yes, 1 to 10.
1 to 10. 1 to 10 also.
So all these plots were acquired. So there was a de-requisition proposal also in respect of which.
And see, my lord, it was taken up for the CSC. But it appears from the
CSC is the requiring body.
Name has been recorded with the name of the CSC. Page? I don't know. No paging next time.
My lord, that is page 49. Page 48. Sorry. Page 48 onwards.
CSC, my lord, is.
My lord, land acquired by the government, then CSC.
CSC is.
For thermal power plant.
CSC, Mr. Bandobad, the plot number 22 has been entirely acquired. Because please see page 50. You may not be having the page numbers.
Sorry.
So,
which page?
Mine is 49. I do not know you have the page editions or not.
20.
No, Mr. Bandobad, have you got the order passed in the earlier writ petition? Please check up after that. After that, these record of rights have been mentioned.
Yes,
some plots, the name of CSC has been recorded in total. Some is in part. So might be that these plots, the proposal for acquisition was for the entirety.
Yes,
De-requisition maybe for a portion.
For which?
Maybe for a portion. Maybe for a portion. It appears so from this record of rights.
But my lord, I don't be for your lordship, my lord. Page 28, no? My lord, no, we can.
Read the CSC.
My lord, CSCI sub. CSCI made party.
Searching for CSC.
Yes, CSC. I already served, but nobody appearing.
When have you served upon CSC? Who appears for CSC?
Page 33 below.
But not delivered possibly in the APU service. My lord, CSC not.
You are
delivered.
saying that it has been served, madam.
My lord, I tell you.
Who appears for usually appears for CSC.
না অন্যান্য অ্যাডভোকেট প্যানেল অ্যাডভোকেট আছে প্যানেল
appears as senior.
Then another notice to see office of the CSC.
Ashun, the grievance
and was allotted by law for construction of the road Mahatpur Shiv Mandir to Mahatpur Primary School. But as per request to the villagers, he has constructed. Video.
My lord, your lordship, my lord, take up my report. My report.
Report.
By the video file. By the video.
Yes.
video is the only supervisory authority, my lord. The work has been done and the executing authority is the my lord, Jila Police. The several, my lord, villagers, my lord, lodged complaint before the government portal, my lord, and the grievance cell. It appears from my lord, page 6. Regarding, yes, read, my lord, to the district magistrate regarding complaint Ombikapati Rai received program implementation such and such. With due respect, complaint construction received from Ombikapati Rai lodged website such and such. Such and such, my lord. Then, my lord, grievance description. The caller of Mahatpur village requested, my lord, it is the DDK portal, my lord, caller team. The caller of Mahatpur such and such requested construction of a road of his area. The road from NH6 to Mahatpur Taltatola is 2 kilometers long and in poor condition. There is an upper primary school, 2 ICDSE schools, 2 large temples along with this road. He assumes that he along with 2,500 people face problems daily. They informed Potosky department in writing but did not receive any response. The caller informed their former local authority in writing and she promised to help, but nothing happened. The BDO came to survey the area but did not respond after that. The caller reported that all roads repaired or new roads the area done by the Panchayat Jila Parishad, so the caller seeks assistance in this. Next, my lord, same my lord by Ombikapati. Then, my lord, Panchayat authority, my lord, taken step. Then, my lord, page 9. It is grievance, my lord, by the another person, Mousumi Raut, page 9. Thereafter, my lord, the government has taken steps for implementation of the road.
Mr. Bandyopadhyay, what is the...
I'm coming. Lord, your lordship, then, my lord. The work of my lord, your lordship, kindly page 22. Page
22, yes.
Page 28, my lord, sorry.
28 of your report.
Of my report, my lord.
28, yes.
Executing agency, my lord.
Rastashri.
Rastashri. Executing agency, my lord. Block and Jila Parishad.
Executing agency is block or Jila Parishad.
Jila Parishad. Then, my lord, page 23, 30. Page 30. My lord, the work order has been issued by the additional executive officer, Purbo Medinipur Jila Parishad. It is hereby directed to immediate work concrete such and such, Mahatpur such and such, if all necessary, if please such and such, my lord. Then the work order has been, my lord, executed by issued by the Jila Parishad, my lord. And executing authority, my lord, is the Jila Parishad. Then, my lord, same page, my lord, this. Your lordship kindly turn to page 34.
34, yes.
Tender has been invited by the Panchayat authority, my lord.
20. 20. That work has not been done. Page 24.
This was not done.
This was done by the...
Because there is order of civil court for that reason.
ভুল তো হয়েছে কোর্টের অর্ডার পাস করেছে নিঃসন্দেহে এটা তো ঠিক কথা কিন্তু ভুল কিছু নেই কিন্তু দিস ওয়ার্ক অর্ডার হ্যাজ বিন মাইলড ইস্যুড বাই দ্য জেলা পরিষদ এক্সিকিউটিং অথরিটি ইজ দ্য জেলা পরিষদ my lord as because my lord the work has been done within the jurisdiction of the BDO therefore he is only to look into the matter under his supervision, my lord. This is the only, my lord, instruction I have got, my lord, from the BDO.
Now, what is the duty of the BDO now?
My lord, your lordship kindly turn to page 5, paragraph 5 of the report filed by the Jila Parishad.
Jila Parishad is respondent number?
4, 3 and 4.
4.
4 is the executive. It is very wrongly done. It is correct, my lord, it is wrongly done.
Yes, respondent number 4, yes, which paragraph?
Paragraph 5, my lord.
Yes.
The proper demarcation shall be undertaken by the competent authority, and if it is found that any portion of the road had inadvertently encroached upon the royalty land, or appropriate corrective measure, including shifting of alignment of the road, shall be considered in accordance with law. Therefore, my lord, it should be, my lord, your lordship pass the necessary order, it should be, my lord.
No, Mr. Bandewat, there are two ways of looking at it. One is, if according to you it is necessary for the public purpose, then you have to take steps in accordance with
My
law.
lord, it appears from the record, my lord.
There are two things, even if.
My lord.
So according to this, it appears that if there is an encroachment upon the royalty land,
My lord.
so then that has to be, either that has to be removed,
Removed, my lord.
or you have the power to acquire that. So what is your decision now? Now first,
My lord, your lordship, my lord, there is the civil court's order, my lord.
Yes.
Remove the, my lord. Then, my lord, your lordship pass the taken up the civil court's order.
so Mr. Dey, are you willing if they acquire this?
My lord, no requisition proceeding. Earlier, I'm coming. My lord, come one.
No requisition proceeding was made prior to construction, that I accept. I'm asking you that whether you are willing to accept compensation as per the, if a proper acquisition proceeding is initiated and you are compensated in terms of the 2013 Act.
My lord, they have said no.
Because, Mr. Dey, there
My
are two-
client said no. Because, my lord,
you will be getting compensation.
well, because my client said, because earlier that video taken first steps, then civil court is immediately removed
Mr. Dey,
and
I
demolished.
appreciate Mr. Bandyopadhyay is also accepting that.
Yes, yes, my lord, it is
There are
correct.
two ways of looking at it. One is to demolish or the in terms of
Should be removed, my lord.
to remove. That is one way. Second is the development of the area. That's the other way. But in the garb of, in the name of development, your property cannot be taken up. That's
My lord.
settled. So now, but the state has the authority
When there is an order of the
to
civil
act
court.
in terms of the statute, so they have to compensate, they have to initiate a proceedings for that. That is why I'm asking you, if you are compensated in accordance with the 2013 Act, whether your clients are willing, you have
No,
taken
my
the
lord.
instructions.
My client said they are not
Your
willing.
lordship's attention, my page 32 of the writ petition.
But see,
Of
That
the
is
writ
the-
petition.
Of the writ petition. That is the judgment of the landed appellate court.
Page 32.
Page 32, last
Yes.
portion, my lord.
Yes, yes.
Plots of lands of the my lord, what is?
Yes. Page 32 is the order of the appellate court.
Appellate court, my lord.
Yes.
page 31, 31. First
Yes,
31.
Yes, yes.
Page 31.
Appellate court. Plot of lands of the plaintiffs within the, remove.
Yes.
Within 3 months from the date of order. In default, the plaintiffs appellants are liberty to next execution before the appropriate court.
Yes.
But they have not put into execution the civil court's order.
Thereafter, it was demolished. It was executed.
No.
Yes, my lord. First step was taken by video. That the video is the party in this.
No, thereafter, it was demolished.
Video was the party first time. And again, my lord, video takes steps.
No. I have no such instruction. Not
No,
It
this
has been
order,
constructed.
when this work order, when this road was constructed, Mr. Bandyopadhyay,
It's a
My lord,
construction.
work
when the tender was floated,
My
my lord is 2024 order ko, my lord,
2024.
2024. So,
My lord,
it was done.
February 24.
So, you have paid to the contractor.
Yes, my lord.
So, then Mr. Bandyopadhyay, now please kindly come to, this is a decree of
My lord, I annexed D of my lord on my
Mr.
report.
Bandyopadhyay,
Additional estimation work order 2024.
yes. So, now please kindly come to the appellate court's order.
My lord.
When this order was passed?
2006, my lord.
Yes.
Yes.
So, if the 2006, this decree was passed,
2013. 2013.
yes, 2013, so it was executed, must be, thereafter you have again,
Second steps.
so it's the second step. So now they cannot execute this.
My lord. My lord,
Video is the party.
my
That
lord, it is
with that
correct,
show.
my lord. The work has been done, my lord, encroaching the petitioner's land. It is correct, my lord. Then it should be demolished in respect of the plot in question. Plot number 2 and
Also demarcation by this BLO.
the second question হবে.
If the BLO
Two
demarcated,
plots are involved in this matter, my lord.
the actual position be demarcated of the BLO, then my lord, your lordship will direct.
দাঁড়ান। রিপোর্টটা কোথায় রাখতে হবে?
Well,
Two
picture
plots
is
are
there.
involved in this matter, my lord.
Now, before that, the Mr. Bandyopadhyay, Do you have the map of this road? No.
My lord, today, my lord, that is not. If your lordship direct, my lord, then.
Only one thing I'm asking you, the road may encompass several plots. Out of that, one plot may be of Mr. Day.
Two plots. Two plots of the petitioners, my lord.
Two plots.
Two plots.
No, are there any other plots of other persons?
I don't know, my lord.
No, only my property.
No other objection. Page 27, my lord.
Only my
Work order once. Show me the work order.
Work order, my lord.
It contains the plot numbers.
No.
So where it contains the plot numbers.
No problem, my lord. Point.
No, there must be some proposal.
30, my lord, it is issued by the additional executive Jela Purusha. There is no mention of plot number.
So where do I get the plot numbers?
Page 24, Mala, page 24, my record of rights. No, nothing.
No. I'm asking him that this proposal was to go through which plots. In all these proposals, Mr. Bandyopadhyay, the plot numbers are mentioned. Why are you saying no?
My lord, it is issued by the Jela Purishad. My lord, it is from Simundi to primary school.
Mentioning not mention any plot numbers.
There are the
may submit one thing.
Where it has been mentioned from Shiv Mandir.
Page 30, my lord.
Page
of the report. Page 30. What order, my lord? First line. You are hereby directed to start work immediately for the work concrete road from Mohodpur Shiv Mandir to Mohodpur Primary School at Mohodpur under Panchkura 1 Gram Panchayat within Panchkura 1 Panchayat Samiti in the district of Purba Mendipur as per agreement executed. It is issued to the Nawab Wood Industries, that is the the contractor in question.
Yes, you have done his job.
Existing some road was there. Some existence of road was there. The same has been should be concreted.
Pay compensation. Pay compensation.
We have
may submit one thing. Only one submission.
If you're not similar, we can demolish. If you're not similar, direct after proper demarcation, which has been enclosed by the at the time of construction of road, that can be demolished. If the
demarcation is to be done.
Yes, which portion it has constructed? That's
page 58 onwards. Page 58
of the writ petition.
Of the writ petition. Well, all photographs are there. Even after receiving the demand.
So that's fine. It's admitted. They are also admitting that construction has been made. Now the only difficulty is that here the plot numbers have not been mentioned in their report. It says from Shiv Mandir to such and such. So there may be 2 of your plots have been utilized. There may be other plots also.
May I submit one thing?
Yes.
The proposed, my lord, the construction from Mohodpur Primary School, Mohodpur Shiv Mandir, but this is it is far from the 1.5 kilometer from my petitioner's property. It is a new plot, new portion. But there is no, my lord, nothing is in the
to you, this is not the area where your plot.
Yes, it is far away from my petitioner's property.
This is another new story.
My lord, he has not stated all these things.
He does not know that he will be coming up with this. His only case is that my portion
necessary, my lord, for that regard.
That is the one part, but may not be by according to
Mr.
Day.
Not my lord is plot number 2058 and 2125. It appears from page 27 of the judgment.
Yes.
My lord, got it? 27.
Page 27.
27. May I read, my lord? Second paragraph. Only the original suit.
No, where is the schedule? Where is the decree? Where is the decree?
No,
decree has been annexed, my lord, no schedule.
Yes.
Where is the decree?
I mean, again,
we start from page 26. Plot number is page 27.
Are Baba decree.
Page 33.
Page 33. Page 33, my lord. It starts from page 33.
Page 33.
My lord, page 31, where the landed civil court has stated.
Where is the decree passed in the suit? Please show me. Have you annexed the trial court's decree? No. You have the copy of the trial court?
No, my lord, only appellate court decree is there. The judgment and degree. But the plot number is there in that judgment.
Judgment and not
in the schedule, not in the decree.
My lord, I'm coming, my lord. My lord, I'm coming.
Page 33, 32.
2 plots, 2058 and 2125.
My lord.
Yes, 2 plots.
Page 27 of the judgment, it has been mentioned. I never found, my lord, any from the decree.
Page 27. Second paragraph.
Yes, I've seen that. What happened to the suit? Suit was dismissed.
Suit was dismissed. It was reported before the under trial judge, civil court.
Ashun. thanked
Yes.
that you have done this pursuant to our request. Paragraph 5.
Utilize the fund from the proposed Malad road. And
There
fund
may be
allotted to the
diversion
other
of
part.
fund.
Yes.
Proposal was different, you have executed in another area.
On Shitala Mandir proposal was there. There's been a Milord, page 29. No, Milord. During routine inspection on 12/7/22, the road, local people expressed their thankfulness to the government fulfilled request demand construct 2 kilometer long concrete. Local
Yes.
people also
So
said,
that is their demand was from Shitala Mandir to NH6.
Not
They said
Mandir.
that yes, our demand was fulfilled.
my lord, then I have to take instruction up to which Milord the construction has been made. Up to which Milord the construction.
But he, BDO himself
If
had
the
admitted.
lordship is not satisfied, Milord,
Because here the BDO's
yes,
report
yes,
is
yes, 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 my
contradictory.
lord. I cannot alter this, my lord. This is the executing order, Milord. Page 29. Page 29, Milord.
Yes.
Serial number 29. 11.
Serial number.
Lord Mahatpur Primary School to Sitala Mandir, Mahatpur under Panchkura Satan.
Item number 11. 11. Yes, yes.
Therefore, my lord, it is the, my lord, that to the extent the work order has been issued. And my lord, thereafter page 30.
SRD. SRD.
To which, my lord, that the work has been done, then I have to take my lord further.
Because the
Otherwise, my lord, I
people will not thank
without,
you if they have not done the
Yes,
work
my
as per their
it is written, my lord, I cannot, my lord, say so. But I shall have to take further instruction up to which, my lord, to the extent that the work has been done.
Well, second
Other
time
than-
desperate attempt by the BDO. Very desperate attempt by the BDO.
ভিডিও তো কিছু করিনি ভিডিওকে তো গ্রামের লোকেরা চাপ দিয়ে পার্টির লোকেরা করিয়েছে তো তুমিও বলছো আমিও বলছো
My lord, day and night, hooligans, police, well, everybody is there. Day and within 7 days we completed the road.
এখানে একই জায়গায় দাঁড়িয়ে আছি।
বিশ্বজিৎ
The
তুমি
petitioners
দাঁড়িয়ে যাবে তুমি ওখানে
claim to
নেতা
be
ছিলে, পঞ্চায়েত সমিতি।
Mr. Bandyopadhyay, please hear this.
এটা নেবেন আমাকে ফাইলটা একটু দেবেন
I am also ready,
you
my
also
lord.
to give some pressure.
I am also, my
Please
lord.
don't take
This is my lord. Kindly consider. I am ready, but my instruction is come, my lord. My lord, he is not could not come, my lord. Then my lord, 1 week time.
On the prayer.
Speaks or second.
Yes.
Lord, I appear for the.
I get to parent of the state council.
Yes. Yes, Mr. Mukherjee, it was adjourned on your ground. Why? What clarification?
Pressure, this section 3A1 notification was published on 21st November 1983. But that notification is not easily available.
Yes.
Because they are, all the officers are within the SIR on a kind of more time. But I find that this was published on 21st November 1983. Under subsection 1 of section 3 of Act of 1920.
Yes. Status report filed by whom? By the state.
By state. In this matter, a report was not called for because identical matter. In earlier writ petition of the petitioner, both the KMD.
Here the report was not called for.
No.
No, but status report is here.
Status report is filed in the earlier writ petition.
No.
Status
20562
report,
of
yes,
2025.
by state.
13 November.
Yes,
By
yes.
state. By state.
13 November.
Report was not called for.
No, not called for, but yes, filed.
Kindly see calculation extraordinary notification 29th November 1983.
Here, my lord is on Shoilendra's judgment. Division bench judgment.
Service section 3 notice upon the
He is on that.
Yes.
The name of the predecessor of the petitioners are appearing in the award list.
Don't over.
But I did that not. Gazette notification is there.
If I will be addressing on that, whether the Shoilendra can stand in the way or not.
All right, make your submissions.
Mr.
Mr. Chakraborty's submission is that it was not served upon.
It was not served upon him.
Yes.
So there was no requisition. Without requisition, acquisition is invalid. That is what sum and substance he has submitted.
Yes.
And not only that, my lord, in the award sheet, my lord, though name is there, but no amount, nothing, my lord, has been mentioned.
Yes, Mr. Talukdar.
My lord, here, my lord, I know that Shoilendra's judgment perhaps will be troubling. But in my respectful submission, my lord, this cannot stand in the way. This judgment cannot stand in the way. In my submission, I will be coming on that. This is par incurium.
Par incurium?
Yes.
Why?
I'll be coming on
Yes.
that. Milord, Mr. Mukherjee will be furnishing that document. Even if, in my respectful submission, Milord, having regard to the facts of this case, to entertain this writ petition, to adjudicate the grievances alleged in the writ petition, whether that may not.
2 of 48.
Milord, yes. এটা না
এটা না Land Acquisition Act 1894 Act 2 of yes yes Mr. Talukdar.
Yes, Milord, my respectful submission is, Milord knows that this Act 2, we are on Act 2. It's a self-contained act. It does not.
Yes.
It need not, Milord, depend on some other statute, because it itself, the act itself provides the machineries, the consequences. And for instance, Lordship may look section 7A. 7A, if your Lordship sees, for instance, I am referring to this section, though not relevant here,
yes.
That in case, if your Lordship takes this 7A,
yes,
if award is not made within the time stipulated, then the notice will lapse. Here, we are on section 3, if your Lordship takes up section 3. Assuming, Milord, though not admitting, that section 3 notice
was not served.
Let us proceed on that. Whether that will vitiate the proceeding or not.
As per the division bench, it vitiates.
As per the division bench, it vitiates. If there is no requisition, there cannot be acquisition. There was requisition, it appears. Bengal Milord, here in Act 2, Lordship will not find.
Yes, sir.
The state to requisition any land.
Yes.
For the purpose of acquisition. But in the Act 2, that is 1948 Act, there is no provision envisaged in the Act that non-compliance of any provision, non-compliance of section 3.
There, Mr. Talukdar, rules is there which provides for service.
But
I think rules is there. Where is the
But
rules?
had it been the intention of the legislature, Milord, that non-issuance of, let us proceed on that.
But Mr. Talukdar, rules have been framed. I think yes.
Yes, rules. How it is to be served. Rule 3 of
yes.
Yes, Rule 3.
Yes, manner of service of orders.
Yes, if it is not done.
Be served on the owner, and where the relates to occupation of an owner not being the owner, by delivering or tendering a copy, by fixing a copy thereof, by sending the same, by fixing a copy thereof on some.
Yes,
So
four modes are prescribed in the rules how to be served. Assuming, Milord, that none of these was availed of. That as per the Soilander's judgment, that requisition, there will be no valid requisition. So in absence of valid requisition, there cannot be valid acquisition also. But my humble submission is, Milord, whether the statute provides any consequence for non-compliance of any provision. Because 7, why I have referred to 7A? 7A, their stipulation is there. The legislature intended that if award is not made within the stipulated period, the 4-1 notice will go. But here, Section 3, even if it was not properly served, as it appears, my lord, my lord, another fold of submission will be, he is referring to, my lord, he is not denying that the document, the Section 4 notice is there. Section 4 reflects that there was 3-1 notice issued. But his contention is that Section 3 notice was not served on him. He was entitled to Section 3 notice. The owner or occupier, it should be served as per the provision, my lord, of Section 3 of the Act. That such a notice should be served on the owner or occupier. How to be served? Rule 3 makes it clear. 4 modes are prescribed. How it is to be served. Let us, my lord, now the question, my lord, I will be submitting, my lord, very humbly, that Section 3 does not provide any consequence of non-compliance. This is not the intent of the legislature. Had it been so, then like 7A, consequence would have been provided there in the Act. But nowhere in the Act, consequence is provided. So whether, if consequence is not provided, the provision cannot be treated as mandatory. It is mere directory. In my respectful submission. In which was not considered, why I am submitting. Here, my learned friend cannot show, my lord. The instance I have taken 7A, the legislature intended that. That is why that provision is made there. But in case of Section 3, it is not done. So legislative intention was not to make it mandatory, but it can be construed to be a directory only.
Position taken.
Position taken long back. If your lordship sees the point position was taken, lordship kindly comes to page 68. Because there were 2 phases of acquisition. He is not challenging the first phase. He is questioning the second phase of acquisition. That is acquisition of 1993-94. In a case of 2/1. In a case of 2/1/2 of 1993 and 94.
No, he is challenging
He is
93-94.
93-94 only.
So this was also under Act 2.
This was also under Act 2. Possession was given, taken, my lord, and handed over to the requiring authority on 31st March 1994. At the bottom, lordship will find the date is page 68.
Yes.
My lord, since it is not so legible, type copy is given, page 70 and 71. And at 71, lordship will find the particular plot is there, 2759. Against that, 0.06.
Yes.
So, my lord, I'll be So in my respectful submission is, my lord, and I will show even from the Constitution larger bench decision in Indore, the right from 1961, the position is settled. That how a provision can be interpreted, can be construed as mandatory or directory.
Mr. Talukdar, there is no dispute with regard to that.
If it is not,
Now,
if
the question is the division bench on this issue
yes,
has held that it's mandatory. Now, that decision is binding on me. Can I say no?
If it
that
is
decision is not binding upon me.
no, my
Unless you can show a larger bench considering this, saying on this issue particular, maybe according to what you are saying, there are very many provisions indoor development has decided. Also, how a provision can be said to be a mandatory or a discretion.
if it is, yes, my lord, I followed, my lord. My lord, to
Here it considers the particular provision of a statute which
Yes.
also specifies it is to be served. Now, the mode has been mentioned in rules.
mode has been
Mode has been mentioned only in the rules. According to you, that this service, this provision is not mandatory. It's a directory one. So even if there is non-service of this order, assuming there is non-service of this order, even then it cannot be
Would
said,
not affect the
requisition cannot be said to be a bad requisition. That's according to you. But the division bench, considering these provisions have held, unless notice under section 3(1) is served,
My
under
lord,
the mode,
this provision, this argument was not advanced in that case. Whether it was not considered in Shailendra's case, whether the section provision of section 3 was mandatory or directory.
yes, it was considered. It was
No,
considered, Mr.
It was, my lord, subject to correction, my lord, it was not.
Yes.
My lord, I will be relying on two decisions, my lord. Lordship will kindly consider. Yes. Shailendra.
Paragraph 42. Paragraph starts from paragraph 39 onwards.
9 onwards.
Yes, 39 onwards.
39 onwards.
We are convinced that in this case, the provisions of 3(2) and Rule 3 has not been complied with. The order of requisition passed cannot be said to be valid for non-complying with the required provisions. Therefore, all subsequent steps taken for acquisition of the land cannot be said to be valid.
I join issue there.
Here,
the division bench taken it as if it is mandatory. That is why 39 to 42.
Yes.
Taking that provision as mandatory, treating that provision as mandatory, this observation, this finding had arrived at. The test was not applied, it was not argued by any of the parties whether that provision is a mandatory one or a directory. If it is a directory, that non-compliance will not affect. If it is mandatory, then certainly it will affect. But no authorities was placed, no argument was advanced on that.
Argument was advanced, Mr. Talukdar. Argument was advanced.
No, directory or mandatory, that issue was not decided there. My lord, subject to correction, my lord. I have gone through the judgment. Whether that provision is a mandatory or directory, that issue was not considered. Which was considered, I will be referring only two decisions, my lord. If your lordship takes a very old decision,
It's, my lord, it is AIR 1962 Mysore 169. Paragraph 5, Lordship. May I read for your Lordship? Huh? Page 169, Mysore. Paragraph 9, I am reading.
9.
Paragraph 5, sorry.
Yes.
As pointed out by this court in writ petition number so and so, the object in enacting, Milord, I will be relying on the Supreme Court decision also. The object in enacting subsection 3 of section 9 of the Land Acquisition Act is to afford to person occupying the land or interested in it to make a claim for compensation, so that the collector might decide the compensation payable to them and order its payments. If in making of that claim or in its establishment, the omission to serve a notice under subsection 3 of section 9
Yes.
has brought about a hindrance, it is clear that the person who was so prevented from making a claim or from establishing it has a right to challenge the award by adoption of suitable steps for that purpose. It is, however, clear that there is no inflexible rule that an omission to serve a notice under section 9(3) always and in all circumstances vitiates an award. It is, however, unnecessary to pursue this discussion, since in the circumstances of this case, it is obvious that in the case of every petitioner, other than the petitioner in writ petitioner number so and so, it could not be said that there was any difficulty presented by the omission to serve them with the notice under section 9(3) in the presentation. Presentation or establishment of a claim for compensation. Out of 6 petitioners, 5 so and so, I'm skipping few lines, must be in those circumstances, it would not be possible for us to hold that the award insofar as it's concerns them is invalid or void. Insofar as the petition number so and so is concerned, it does not appear that he ever intervened in the acquisition proceeding. Not there is any material to show that he had any interest in the land or was it its occupant. However, that may be, it is clear that there is nothing to show that the collector knew or believed that he had any interest in enjoys the service of notice only on those who are known or believed to have an interest in the property which is proposed to be acquired. And so long it is not established that the petitioner in the writ petition or so and so was known or believed to have any interest in the acquired property, it cannot be said the collector was under a statutory duty to serve a notice on him. At any rate, the omission to do so cannot be made the ground for an attack that the award to any extent is void award.
Yes. Yes.
Milord, next very vital judgment, Milord, which was also considered in Indore development authorities. This is reported in 2010, volume 13, SCC, page 98. Milord, I will be placing few paragraphs, paragraph 14 to 25. May I place, Milord? The small paragraphs. Milord, section 9, I am reading from paragraph 14. Section 9 of the Act provides for an opportunity to the person interested to file a claim petition with documentary evidence for determining the market value of the land. And in case a person does not file a claim under section 9, even after receiving the notice, he still has a right to claim
right to make an application for making a reference under section 18 of the Act. Therefore, the scheme of the Act is such that it does not cause any prejudicial consequence in case of notice under section 9(3) is not served upon the person interested. While determining whether a provision is mandatory or directory, I'm coming on that. While determining whether a provision is mandatory or directory, in addition to the language used therein, the court has to examine the context in which the provision is used, the purpose it seeks to achieve. It may also be necessary to find out the intent of the legislature for enacting it, and the serious and general inconvenience or injustice to persons relating thereto from its application. The provision is mandatory if it is passed for the purpose of enabling the doing of something and prescribes the formalities for doing certain things. Then, my lord, a few cases are cited here. Paragraph 16, 17, 18. Up to 23, my lord, so many decisions were. My lord, should I place all those?
Paragraph 25.
Yes.
This is well settled.
Yes, yes. Then, my lord, I'm coming straight away coming to paragraph 25. So many decisions were relied on, my lord, discussed there up to paragraph 24. The law on this issue can be summarized to the effect that in order to declare a provision mandatory, the test to be applied is as to whether non-compliance with the provision could render the entire proceeding invalid or not. Whether the provision is mandatory or directory depends upon the intent of the legislature and not upon the language for which the intent is clothed. The issue is to be examined having regard to the context, subject matter, and object of the statutory provisions in question. The court may find out as to what would be the consequence which would flow from construing it in one way or the other, and as to whether the statute provides for a contingency. My lord, I'll be emphasizing on this sentence. Construing provides for a contingency of the non-compliance with the provisions, and as to whether the non-compliance is visited by small penalty or serious consequence would flow therefrom, and as to whether a particular interpretation would defeat or frustrate the legislation. If the provision is mandatory, the act done in breach thereof will be invalid.
Yes.
So here, my lord, on what, my lord, I emphasize, my lord, that provides for a contingency of non-compliance. The statute does not say so. The legislative intention is clear from plain reading of the provisions of section 3. Yes, how to be served? The rule says that it is to be served on this way. But if not served, the consequence is not provided. Although the Act 2 is a self-contained code, is a complete code. Whether non-compliance of the provisions regarding passing of a word, consequences provided in 7A. So from the legislative intent, it appears that section 3 cannot be regarded as mandatory. It is directory only. So even if, assuming there was non-compliance, that would not vitiate the proceeding. This particular judgments, this provisions of law were not taken care of while passing the judgment in Shaileन्द्rnath Pal's case. If it is not done, my lord knows, even then, my lord, one decision, my lord, I will be citing, since I have uttered. It's a, if not.
But Mr. Talukdar,
My lord.
The decision in Shoilendra was passed on March 24, 2010. And this decision of the Honorable Supreme Court in 2010, volume 13, was delivered on May 25. It's a subsequent judgment. Where was the occasion of the division bench to take into consideration judgment?
But here, if your lordship sees,
Cannot be, this judgment cannot be, consideration cannot be a ground to
no,
hold,
no,
because it's a subsequent judgment.
no, in that event, the decisions I relied on from paragraph 16 to 24, there are the decision which are prior. Upon considering all these decisions, paragraph 25 has been summarized. That is why, my lord.
All right, yes.
So all these decisions are prior decisions. All these decisions are, my lord, 52, 65, 76. So law was then settled at the time of passing the judgment in Shailendranath Pal's case. Law was settled on that. And it is, my lord, time and again this weather directory, and there are the gallons of. So, my lord, I have not placed these paragraphs, my lord. That in Major's case, the Honorable Supreme Court, upon considering all these decisions.
So according to you, that was a summation, previous judgments were there.
And those judgments were right from 1952 to 76. So law was settled at the time of passing this judgment, which was not taken care of while passing this judgment. If not, my lord knows that if a judgment is delivered in ignorance of a provision of a statute or in ignorance of a law settled by the Honorable Supreme Court, that will be held as par incuriam. My lord, only one decision, my lord, I will not trouble your lordship so much. There are also many judgments on that par incuriam. I have brought one paragraph. 1990, volume 3, SCC 682, paragraph 40 to 40.
Paragraph
40, 41 and 42.
40 to 42.
Yes.
This is on par incuriam.
Yes.
1990 কত volume?
Volume 3. এটা একটাই কপি আছে। 468 বলছি ধরো 682
2019 বলে 2019
কি 1990 ভলিউম 3 May I read below? I am reading paragraph 40. Now we deal with the question of par incuriam by reason of allegedly not following the Constitution bench decision. The Latin expression par incuriam means through inadvertence. A decision can be said generally to be given par incuriam when this court has acted in ignorance of a provision, a previous decision of its own, or when a high court has acted in ignorance of a decision of this court. I'm on this here. It cannot be doubted that Article 141 embodies as a rule of law the doctrine of precedence on which our judicial system is based. Bengal immunity, it was held the words of Article 141 binding on all courts within the territory of India, though wide enough to include the Supreme Court, do not include the Supreme Court itself, and it is not bound by its own judgment, but is free to consider them in appropriate cases. This is necessary for the for proper development of law and justice. Maybe for the same reasons before judgments were given in the House of Lords in case number so and so. Then it is quoted.
Their lordships regard use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It
Yes.
provides. So I'm skipping over that on that. Then 41 also, my lord, the quoted portion, it is quoted from the Halsbury's Law, England. Then 42.
Yes.
So in view of this, not having considered the settled position of law, the judgment rendered by the Honorable Division Bench in Felona Pulk's case, in my respectful submission, my lord, may be held as par inquiry. It is not binding.
Yes.
So now, my lord, I will be coming on the different aspect altogether.
Indoor development you wanted to cite?
Yes. In my lord, only one paragraph.
Don't have
This
copies.
Because of his
You are an authority representing a statutory authority, Mr. Talukdar.
My lord knows that how we are.
Statutory authority, you are representing a statutory authority. And you are also not making photocopies of a decision of a Supreme Court.
Many, I made so many copies. Only one paragraph, 142. Measures was taken into consideration.
Paragraph 142.
142, just 2 lines. I opened that.
No. I've seen that. Please let me note the citation.
2020, volume 8, page 129.
Paragraph 142.
142. There.
Yes. So according to you, once is vested, it cannot be divested, even if there is some irregularity in the acquisition proceedings.
If it is considered as an irregularity, it can be. If it is a directory, I'm
if there is some irregularity in the acquisition proceedings,
it can be considered as an irregularity.
Maybe an irregularity in non-service of the copy of the order.
Copy of the order.
Because will be fatal or will lead to any penalty. So same thing that it's not a mandatory.
It's not a
some irregularity here and there.
Even if it is construed to be a directory one, non-compliance thereof.
I think perhaps this provision, once it vests, cannot be divested. You and the Advocate General appeared in one matter. I think I have decided.
That was a different issue there. But here I am referring to
what happened to the challenge to that decision?
Now pending before the Supreme Court.
Before the Supreme Court? Who has challenged before the Supreme Court? Before the division bench, you lost. It's pending.
It's pending.
I think that issue was, I considered once vested whether it can be divested.
That
you cited, I considered this.
Here not.
You are led by the Advocate General in that.
Yes. Here not on that issue, but measures was relied on. Another paragraph, my lord, for few minutes, my lord, keep this book. I will be relying on, and if your lordship turns, paragraph 148.
148.
148. 148.
Yes.
It's the
Yes, vesting. This paragraph you cited in that decision.
in that that's why 148, 149.
Yes. This quotation, what's the impact of the word vest? What is the
Vest.
impact? I considered this. Yes, please.
That I remember that.
Yes.
My lord, now, so my lord, my first folder of submission.
Please give me one. In that matter, Mr. Talukdar was also Act 2 of 48.
Act 2 of 48.
Act 2 of 48. I think I made a distinction between Act 1 of 1894
Here
Act
also,
2 of
here-
48. I think this decision I distinguished on that aspect.
Majors was not.
Considering the provisions of Act 1 and Act 2.
Majors was not cited before your lordship. It was cited.
No. Majors was considered by this. No, I think considering this, your argument of vesting.
Vesting. On vesting, my lord.
Yes, I considered the relevant provisions of Act 1 as well as Act 2 and I've given my reasons.
Because
as
that
to
was
why
switched
that principle will not apply here.
That was switched to initiation was under Act 2. Later on,
After
switched to Act 1.
9.3a3b was done
Yes,
to Act 1.
9.3b was invoked.
Yes.
So, my lord, having regard to this, my lord,
that was the case where there was no 4.1a.
Yes.
In that matter.
There was no.
Here is 4.1a.
Here is 4.1a.
So that was the distinction in that matter.
So there are.
What point of time the vesting will take place, I think I considered that.
And more so, there was another issue. Subsequent purchaser. They were the subsequent purchaser who challenged.
That was the other issue.
Other
but
issue.
with regard to the vesting, I think 4.1a. Yes.
Whether vesting will remain.
At what stage it will vest?
At what stage? Because according, as per 4.1.
Unless there is 4.1a, there cannot be vesting.
There cannot be vesting. The moment 4.1a will be issued, under 4.2, it will vest automatically. Then the other provisions are for the purpose of assessing compensation in the manner provided in the Act. So, then owner will get an opportunity. 5 is there.
Those are the other provisions. Yes.
Here, what the Shoilenros in view of this, my lord, Shoilendranath Pal's case judgments, my lord, cannot be said to be a good law. It is par incuriam. What was passed in ignorance of the law settled by the Honorable Supreme Court.
Yes.
In regard to the way that is directory or mandatory.
Where is the copy of the earlier writ petition?
Yes, I have brought that. My lord.
My lord,
Though it was the task of.
I have also, my lord, handed over the copy.
You have handed up. Yes.
Without an extra, I am giving for complete set.
Explanation I have given, my lord. Teachers were, my lord, get the photocopy, my lord, or the stitches are there.
What I get it. Now, my lord, the second question.
Please give me a
yes. The same paragraph, 5 to 7, lordship.
It was November 1983.
ওটা আমি দেখিয়েছি।
Yes, Mr. Talukdar.
So, my lord, my first folder of submission, my lord, I conclude
that Shoilana's judgment rendered in Shoilana's case cannot stand in the way, as the same has been rendered in ignorance of the laws settled by the Honorable Supreme Court, and it is par incuria. It is not binding. And so far the interpretation of the section 3, my lord, according to me, it is not mandatory one. It is a directory. Non-compliance will not vitiate the proceeding, which is, my lord, I have also shown to your lordship the paragraph in Indoor's case also. Even if there is irregularity.
Yes.
If it is, if it was not served properly, even
more?
Yes. Yes, I have I have other issues. Yes. Now, my lord, the question comes, my lord. Now I come to this petition. Here, whether if your lordship sees the award passed in this case.
Yes.
Which starts from page 72.
Yes.
My lord will find at next page, lordship kindly turn to the next page, page 73.
Yes.
The name of Nagendranath Das is there. My lord kindly note that. And plot number is there. My lord got it? Plot.
Yes. Measurement is also there.
Measurement is also there. Petitioner claims is that their land comes within the proceeding of 93-94. If that be so, apportionment is also there. Amount is also there by the side of Nagendranath Das.
This is with regard to 53-54.
50. No, about 2759.
No, sorry. This is with regard to 93-94.
Yes, 93-94.
Where do I find that case number?
Case number, lordship will find here this on this copy. In fact, it is handwritten, but in the affidavit they have explained, they have stated. Lordship will find page 51
of the
51 of the writ petition.
51.
It's a portion of the report filed by the state. It starts from 50. 3-2.
Yes.
3-2. The case is referred. And Roman 4, lordship will find that regarding declaration of award in the name of Nagendranath Das.
Yes.
So award was passed in favor of Nagendranath Das. And this person, this petitioner,
he is not challenging this.
He is challenging this 93. Petitioner's claim is his predecessor purchased land, 3 quarters of land from Nagendranath Das. Lordship, kindly come to the deed. Only one page, page 36. His predecessor is Pramotho. Here, Kobola Grohita, purchased from Nagendranath.
Pramotho, what is the name?
Pramotho Ranjan
Datto.
His predecessor, petitioner's predecessor.
Yes.
Purchased land from Nagendranath Das.
Yes.
Award shows that Nagendranath Das, the award was passed in the name of Nagendranath Das. Now question comes. Petitioner in the writ petition, though aware that their predecessors purchased the land in 1968, but does not say anywhere in the writ petition whether Pramotho, after purchasing the land in 1968,
mutated his name in the revenue records.
In the revenue records. Records was not updated. Means Pramotho did not recorded his name in the ROR. So, was, my lord, I am putting question to myself, while passing an award in 1993 or 94, even till date, the petitioner could not produce any record, that his predecessor Pramodonath or they themselves had ever recorded their names in the ROR. So was, my lord, I am putting question to myself in view of the settled position of
When
law.
the possession was taken?
In 1994, March 94. I have shown to your lordship the page.
March 94.
31st March 1994. The possession was
Till
taken.
that time, there is nothing to show that in the record of rights their name was there.
Whether collector was obliged to serve notice upon promoter.
Order upon them.
On them. No, my lord knows that case. Even then, my lord, I'm relying on only one decision.
Yes.
It is reported in 2009, volume 10, SCC, page 664. Paragraph 8 to 12.
Yes.
This position is not altered till date. There is no obligation on the part of the collector to hold an inquiry to find out whether there are any other persons interested in the land or whether there are any vested remaindermen in addition to those whose names are entered as the owners, holders, occupiers of the acquired land. Nor does the collector have any obligation to issue notices to persons whose names are not entered in the revenue records. This does not mean that the persons whose name are not entered in the revenue records do not have any right in the acquired land or they lose their claim to compensation. Their interest and rights in regard to compensation are protected by the provisions relating to apportionment of compensation and provision for referring the dispute to a civil court. What was failed from your lordship on the very first day? The money is lying with the treasury. The persons believed to be interested in the acquired land, if their names are disclosed to the collector as persons having an interest in the acquired land, though their names are not entered in the revenue.
Paragraph 12 is the ultimate finding.
Ultimate finding. This is the
those whose names were entered or recorded as owners in the revenue. That question I put to Mr. Chakraborty on the
very first day, my lord, put that question. So collector was not obliged to make a roving inquiry to find out. And it is not their case also in earlier petition.
They will not also go to the Panchayat office to see who has paid.
Yes, to collector is not obliged. This is the law. This is, and though this judgment was passed in 2009, the position is.
This is well settled.
It is well settled. Still holding in the field.
Yes.
Now, my lord, another point argued before your lordship, showing several documents that they are residing there. They are residing there, still residing there, and they have many other ancillary documents to show that they are residing there.
House property is there.
House property is there. Whether all these documents can come in the aid of the petitioner to content. If your lordship, on that very small judgment, if your lordship takes up this is reported in 1997-9 SCC 544, paragraph 3 and 4.
Yes.
Page 544, 5, paragraph 3 and 4. Paragraph 4 has gone too far. Even recording will not, cannot help.
No, has it been recorded in his name in the record of rights?
No. He is contending that he has muted his name with the KMC authorities. That
KMC and other things will
not do. Paragraph 4 is clear.
Yes.
My lord, this position, Lordship will, for a moment, if your Lordship turns to the Indor's case, my lord, if I correctly remember, 149 perhaps, this has been reiterated, 148 or 149. After vesting, remaining in possession, he will be treated as mere trespasser. That has been held.
Also well settled.
Yeah, that is also well settled, my lord knows. It is reiterated in those cases also.
After the vesting, everything free from all encumbrance.
All encumbrance.
So even if he is anyone is in possession, there are trespassers. Which paragraph? Please take up
148. My lord, keep it. Keep it. I have a copy.
149.
148. Maybe. My lord, it would be 149.
149.
149.
Yes, he's only a trespasser.
Only a trespasser.
Once vesting takes place and is with possession.
Yes.
After which a person who remains in possession is only a trespasser. 136. Yes, 57 Supreme Court. I have said that. It's long settled.
Long settled.
57 Supreme Court.
So here it is undisputed 41A was issued. So in consequence of issuance of 41A under 42,
it stood vested.
Stood vested.
Once it stood vested,
and
any possession of any person is that of a trespasser.
And here a word was also passed. A word could not have been passed in the name of Pramotho because of.
Since he is a purchaser, his right to claim compensation before the appropriate authority, that is already there. And apportionment and other things.
So he Milord cannot also claim any equitable right by remaining in possession. He is a mere trespasser in view of the settled law. Now, Lordship kindly comes. Another point is, Milord, the delay. The delay. The petitioner from paragraph 5 to 7 in the earlier writ petition as also in the present writ petition, it will appear that these petitioners were well aware of acquisition. But they did not take any step before this writ petition was filed. This delay also stands in the way to hesitate their alleged grievances at this stage. After
land acquisition, Mr. Talukdar, you know.
My lord, I am not. That point also comes in.
You have relied upon certain decisions also. I have considered the issue of delay.
No, I am not on that. That their entitlement to the compensation will be forfeited. No, that I am not arguing on that.
Whether they can challenge the proceedings at this
proceeding at this stage.
I think there is a decision also on that.
Yes.
At this present moment, they cannot.
They cannot. Only
the acquisition proceedings.
Only T4 decisions, my lord, I will be citing.
Why 3-4 decisions? One decisions will be sufficient, Mr. Talukdar. On one point.
For my satisfaction.
The one is, according to you, is the most comprehensive one. You can show that.
Then,
Or the latest one, which will take into consideration the earlier one also.
yes, that also. No. My lord, may I, for my satisfaction, my lord, may I just. This is reported in 2006, volume 11, page 464. Paragraph 22.
UP Jal Nigam, I think.
My lord had considered in earlier case.
I've considered.
Yes. Lord had considered.
This is on
2611.
This is on retirement age. Service law, Mr. Talukdar, I tell you that there's a distinction.
Yes.
Delay and latches in a service jurisprudence, because most of the decisions very will be finding. Delay defects. This is on service jurisprudence.
Yes, I'm taking back this. Already we are off.
Yes. How much time it will take?
Only 10 minutes.
Yes.
My lord, this is very small decision, but I think, my lord, 10.4, paragraph 5 to 11 are very relevant. They reported 2010-4 SCC 532.
Yes.
And another lordship will also consider this. Another is 2012, volume 1, page 60.
Which paragraph you are relying upon this?
5 to 11.
5 to 11.
5 to 11.
Yes.
Another is Relevantis case. My lord had also earlier considered 9 to 30.
Yes. Delay ground you are taking.
That only one decision which I did not cite in that case, I am citing now.
Some you have left it purposely.
No, not purposely.
Yes.
Page 66. Paragraph 9 to 13. Leelavanti.
Paragraph
9 to 13.
9 to 13. Yes.
And this was not considered by your lordship. The Porak construction was not considered.
But what was considered? Please give me that and my
46, 47, and 48.
Paragraph?
Paragraph 46 and 48.
46 and 48.
48. 2008, 16, SCC 513. My lord, I think, my lord, I should not trouble your lordships too much. There are several judgments on that.
Yes, delay this way, that way.
That way.
All judgments are there.
Here we are not denying. Here the money is lying with the treasury. He can resort to avail that appropriate procedure. He can.
No, if he can set aside this 2013, because
Then,
he knows what is the.
And my lord knows in the judgment the trend of the individuals had been considered, taken note of in Shiv Kumar's case, and also in the some persons, though acquisition was to their knowledge set tight, and when 2013 Act came, they jump upon to get that.
That has been clarified in Indo.
In Shiv Kumar also taken note of that fact.
Yes. Mr. Talukdar, please give me a copy of this Indore.
Indore.
Take back the book.
I'll take return. After your lordships will deliver judgment, I'll take back.
All right.
I will make suitable reply, my lord, on the point of mandatory and directory. On the point of mandatory and directory, the Act itself says, because it is a special statute. Well, at that time, original Act 1 was in force. But my humble submission before Lordship, my lord, why this Act has been acted. My lord, I will place certain judgment and my lord, on the point of limitation also to Karam Kana Joshi, the subsequent judgment passed by the Honorable Supreme Court. In land acquisition cases, my lord, some liberal approach, my lord, are to be, my lord, taken into consideration. But section 3 and 6.
Delay, Mr. Talukdar is not very serious because he knows. He knows, but he has taken all grounds. That is why he has taken this ground of delay. May not be on the ground of delay, but the other ground.
No, section 4 is there. My lord, unless it is properly requisitioned.
Can come at 2 p.m.
I'll get ready, my lord, after going through the judgment. But my lord, kindly as per your lordship's convenience.
When can you come back?
তুমি কবে রেডি হতে পারবে বল
Next week.
শুক্রবার তোমার ইচ্ছে তোমাদের আমার তো আমি তো আর কিছু
Next
Next
week.
week when?
Any day or zero lord.
Hard. Yes.
Within the statute, my lord, law point, I will argue. No new factual aspect.
As a part matter.
Mr. Mukherjee wants.
No. I do not know what will happen next week, December.
I do not have any.
Contemplating anything, Mr. Mukherjee?
Very difficult.
Lordship, under compelling circumstances, Your Lordship, I am mentioning this matter.
My doctor's appointment is there. Item 13 tomorrow.
13. You are for the petitioner.
I am for the respondent.
What do you say?
Consent, with consent.
All right, 13 টাকে not today করে রাখুন।
Lordship, on
ঠিক আছে, 13 টা মার্ক করে রাখুন not today করে।
Lordship, on last Friday, my mentioning for extension of interim order was granted by Lordship, but the file was also requisitioned, but that matter has not come up in the list. And it is informed that but the file, it is informed that
You have said that
lying
the
in-
file has come, requisition made. দেখে নিন ওটা। Yes.
his junior, I also intimated his junior.
He has not come today.
Yes, he said, his junior said that one Devjani Ghosal will appear. The one Devjani Ghosal also called me that she will appear at 2 p.m. But now she is coming.
So Rudrajyoti Bhattacharya is appearing.
Yes. But what do you say, madam? This was withdrawn by them. Now they want some observation with regard to condonation of delay.
Then it should be heard.
Tomorrow?
Tomorrow, Mr. Bhattacharya is not well.
When he
Is
will
it on Friday?
Sir, Bari, I think you better, but otherwise this will delay. This will further delay. Because do you have a copy? The Arbitration and Conciliation Act, Section 34.
Yes, madam. 34(3).
I can only say that the time during the pendency of this, if you are entitled to, you can apply there. That is the only thing which can be done.
But 90 days is the maximum limitation there, sir. From the date
That is the difficulty. That is the difficulty for which.
of post this honorable court on month of August. At August to November, this petition was pending.
That is why. So you can take the benefit of this because
পিটিশন প্রসিডিং নিচের কোর্টেতে করব এখানে একটা ডিলের প্রশ্ন আছে সেটা কোর্ট একটা অবজারভেশন দিয়ে দেবে শুধুমাত্র যে যেহেতু রিট পিটিশন পেন্ডিং ছিল সেটা আমি এখানে আর কিছু নেই এখানে
That is the reason behind delay, তাই তো?
শুধু ওইটুকু আর কিছু না।
That delay should be condoned. You are in the wrong court. That delay should be.
That's the only. Nothing else.
Petition was pending.
Nothing else.
The
এখানে আর
petition-
কিছু নেই।
It was in the wrong court and that observation. The delay will be condoned.
This is wrong. আর কিছু না।
I'm the only junior to the. এতে তো কোনো অসুবিধা হবে না। It's just a contradiction. Wrong কোর্টে পড়ানো হয়েছে।
Nothing else.
it may entertain the application within a further period of 30 days, but not thereafter.
Yes.
So the statute bars, Mr. Bari, whether the court can extend that. That's the difficulty. Now, Limitation Act to Dinto. Section 14, if you are entitled to, you can apply there. But here extension will be a problem because the statute do not empower this. Because after all, extension means it has to be exercise of powers under Section 5. The statute bars because there are very many decisions on this. After that, it says no.
Only observe that while condoning the delay, they shall consider since the writ application was pending for such period. But only that one. I am not saying for condoning that. Some observation so that while condoning the delay, they can consider.
Question would be whether you can take the benefit of section 14 of the Limitation Act. When Mr. Bhattacharya will be available?
Available on Friday.
Friday he will be available. Mr. Bari, don't delay in filing. File it, then I'm saying.
Very good.
Otherwise, there will be a further
Let it appear Friday on 2 p.m.
Friday 2 p.m.
Mr. Bhattacharya has had a spine surgery, so he cannot come quickly to the court. It takes time to come. Let it be at 2 p.m. It will be. Sure, he will be available.
So, if it is on the next week, also the same problem.
2 p.m.
At 2 p.m.
He cannot come at 10:30. He cannot come to the court.
All right, 2 p.m.
Friday 2 p.m.
Now he's coming or he's.
He's coming. He's coming.
Asu. Let's call the next matter.
Item number 11.
Yes. Only the wrong recording in the record of rights.
Here, my lord, your lordship fine.
Withdrawn from requisition.
Yes, it has already been withdrawn from requisition, but still it appears that they are claiming title or
The record of rights.
In the,
So according to you, there's the wrong recording in the
not
record.
recording. I am not on the record of rights. My case is that they are trying to.
You're on wrong recording in the record of rights, Mr.
I'm not on that.
Saying the title is with you, but the record is.
Deregulation. It has deregulation. Now still they are claiming.
What is more in the correction of record of rights?
I am not on correction, my lord. Whether the state have any interest over the property or not. That is the precisely what is.
Where is Mr. Banerjee?
This is the precisely my argument. Record of rights, I'll go.
Very busy counsel. In all matters, he is appearing, but he's your friend, Mr. Rai. He's assisted by some junior.
Must be.
Pass over. Yes, next.
This is my application.
Yes, Mr. Pan.
Yes, Mr. He is appearing. He was supposed to file a
Any resolution from 2 p.m.
3 p.m. 3:30.
No, state advocates are not appearing from 2 p.m. None of the state advocates are appearing.
Busy council there. No, my lord, on 10th of November 2025, your lordship directed them to file a report in the form of an affidavit.
None of them are here, Mr. Pan. What can be done?
So let me wait over here, my lord, for a short person.
Pass over next.
13.
13 not today. Yes.
14.
None appears for the petitioner at same order. Dismiss for default. Next.
16 Lordship, I am for the petitioner.
Well, 15 I am for the petitioner. Well, 15 I am appearing for the petitioner.
16 Honorable.
15 you
15
did
man.
it has been dismissed for default.
Item number 14.
My lord, the online was there. The some difficulty was there online, my lord.
It was on my way. Lordship, kindly keep it tomorrow, Lordship.
No.
Next.
Pass over.
My lord takes up 15, my lord takes up 15, my lord. I was there on the online, my lord.
15 who is for the state. 15. You did not respond at that point of time. Yes.
No, I was getting, but I was not allowed. That is the reason. Kindly if short pass over, then I will come in the court, my lord.
Passover.
But not today, anything, my lord, anything.
Passover, yes.
Pass over, my lord, yes.
Passover, yes. Call the next matter.
My lord, I am for the petition. 16.
16.
My lord, service has been effected.
Yes.
Lordship, before I open my brief, I will try to give a glimpse, my lord, of the bird's eye view of the matter. Is that it's a matter in respect of land losers' employment. There are three number of writ petitioners, but the claimants are three in number.
Who is appearing for Eastern Coalfields?
So Shiv Shankar Banerjee used to it normally appears. This is the third round of litigation. Earlier round of litigations, Mr. Banerjee appeared.
Yes.
My lord, initially, my lord, I executed, my lord, certain deed of sale in favor of ECL after the land was used by ECL. Thereafter, my lord, because the matter was not taken up by them, I claimed employment under the, my lord,
because the land was.
Lord, I sold the land after it was used. After it was used by the ECL, I sold the land. There was a condition, there was a proposal, Miller policy on their part.
Sold it to whom?
To the ECL.
Not acquired.
Not acquired. Sold.
Yes.
Under there was a policy policy was that for 2 acres, 1 employment. And because
sell, you will get 1 employment.
1 employment in respect of 2 acres.
You have sold.
Total, it's a 6.60 acres, 3 writ petitioners, and we were under the scheme of tagging. 2 acres individually, it comes to 6 acres and something. 3 employments. Now matter was not being, after that, this was not being taken up. I filed a writ petition initially. The honorable judge single judge on that, in that writ petition, there was a direction. The ECL was saying that I was not the owner of the land. In that first writ petition, the direction was that I must be considered as a land loser and accordingly treated in the employment process.
If you are not the owner, how can it be treated to be a land loser?
It was, my lord, considered and disposed of in the first round of litigation, first writ petition.
It was decided whether you are the owner or not.
It was decided. It was decided. They carried the matter in appeal. In appeal also, it was affirmed in my favor. I, my lord, carried and also stated that I am entitled to the policy of 2002, 1 and 2. Thereafter, the matter was taken in contempt. In contempt, the ECL comes and says in the meantime, they pass an order. Though there was not a direction to pass, Lord considered it afresh and pass an order, but they pass an order saying that my land does not come to 6 acres. In the contempt jurisdiction, order was passed, setting aside the fresh order that was passed by the ECL. ECL carries that order in the contempt in appeal. There, my lord, the honorable division bench in the appeal in the contempt directed the writ petitioner with a liberty to that I can challenge it before the writ court, my lord, afresh.
Oh, so that order setting aside, their order was set aside by the division bench.
my lord.
Giving you liberty to challenge
In the
that.
contempt jurisdiction, my lord, it was passed, so it said the contempt court couldn't have done without framing of issues.
Now you are challenging
But
that.
thereafter, I carried it in SLP. SLP was admitted initially. At a later point, when the matter was being heard, then the Honorable Supreme Court was of the opinion, because a fresh order has been passed, again, the one concession was given to me that I can file a fresh representation that may be decided by the ECL. Now ECL has decided the writ petition. My representation. Fresh representation after
So
the
after
SLP.
that, you have given a fresh representation.
My lord. After that, it has been decided and brings me before your lordship.
And they have maintained the earlier order passed.
Not maintained. Initially, before the single bench, my lord, their case was that I'm not the owner. Thereafter, my lord, before the division bench, my lord, and the earlier round, my case was that.
Show me the order which you are challenging.
My lord.
First, show me the scheme pursuant to which you are entitled.
But the policy is at page number 74.
74. Where is that?
My lord, in the next page, my lord, at page number 75. My lord, at the first line, one employment against 2 acres of land taken from the landowner. The ownership should be absolute.
Page 75?
My lord, page 75 of the writ petition.
Yes.
It's dated, my lord,
number?
the document is dated 26th of August 2001.
Point number?
My lord, it's my lord, the point number 1.
Point number 1.
Point number 1.
1.
It is, my lord, it's properly, my lord, no, it's not legible. Point number 1. That's the first line that's beginning in page number 75. P11 collectively.
75 starts O. That is point number O.
My lord.
Point number 1. Yes, one employment.
One employment against 2 acres of land taken from the landowner.
But this is subject to vacancy.
My lord, I am.
Please see page 74, first paragraph. Everything comes within that. Provided there is a vacancy in the company or in the subsidiary company.
But I'm led by Mr.
Condition.
But I'm led by Mr. Banerjee.
Some policy documents are missing, my lord, in this writ petition. Some policy documents are missing in this writ petition. My lord, they kept on, my lord, changing the policy every week once upon a time. My lord, initially the policy was 1:1. They would call it 1:1, meaning thereby for every acre of land, my lord, one employment would be given. Because, my lord, the philosophy was that, my lord, when I lose a land, I lose, my lord, two things. One is, my lord, a property, and the other one is, my lord, right to livelihood. Later on, my lord, this policy came.
This is not acquisition.
This is not acquisition in the sense my lord is thinking about.
No, this is sale.
Yes.
So if this is sale, so you are
whether I would be entitled to twofold benefit or not. My lord, that's answered by the Honorable Supreme Court, by my lord, the Honorable Division Bench of this Honorable Court. My lord, there are so many. My learned friend knows, my lord, better than me.
Have you seen the latest Supreme Court decision on this?
Lord, whenever I do a matter, my lord, I come across the latest decision which I never know. My lord, I have not seen. I have not seen. But my lord, my learned junior says that, my lord, probably, my lord, the judgment my lord is, my lord, hinting at is on, my lord, acquisition of land. Possibly. My lord, I have not gone through that. My lord, my learned junior is more equipped than me. But, my lord, I think we should, my lord, take out, my lord, file a supplementary affidavit, bringing on record all the policy documents which are prevailing, my lord, at the material point of time.
What is the decision which you are challenging? Please show me that.
Page 170.
170.
My lord, the issue which they have raised in this, my lord, decision impugned in this writ petition is also no. I'm so sorry, my lord. So sorry. কত দুষ্টুমি করছো সব কটা মামলায় তোমার মত সঞ্চিতা দি তো আর আসেননি। Oh, you are the savior of ECL. ECL personified. এটা এসপি তালুকদার সাহেব সব একসাথে নিয়ে বেরোতে হলো ভাবে তখন একই করছিল এসপি তালুকদার সাহেব তখন 7 নম্বর কোর্টে বসতেন জাজমেন্ট আছে সুপ্রিম কোর্ট অব্দি গেছিল গিয়ে নামটা মনে পড়ছে না।
Now, Mr. Banerjee, only one thing. So you are relying on the policy which says for 2 acres, 1 employment.
And they are saying individually 2 acres. That's their reasoning. They say this is the should be in one pocket. Millard, I cannot club Millard so many Millard land losers to claim one employment aggregating their land as 2 acres. That I cannot do. If these are fragmented,
If
these are
your
fragmented.
If your share is less than 2 acres.
No, this is also decided. This is also decided by Justice SP Talukdar, which travelled up to the Honorable Supreme Court. Exactly this was the issue. Now, Millard, Mr. Banerjee is ECL personified. Millard, he knows it. Let us come back with that policy.
So that policy has not been annexed.
No.
So your junior was.
But the policy is there. Millard, this policy got amended, clarified, rectified from time to time. Millard, I need to bring those on record.
According to you, that
Everything is clarified.
Is a portion.
Yes, everything is clarified.
Yes, Mr. Banerjee, what do you say?
Nothing. My learned friend also appeared in a matter.
যেটা তুমি কন্টেম্প খাচ্ছ সেটা
Lordship, in one matter where he knows speculative action.
No, if he is
No, Lordship, there is, I tell you.
As per the
In
policy, if he is entitled to.
Policy never says that after I purchase, I will give you something. After I purchase, I will. First, they have
the
to say.
policy. Why do you say so? 74 says so.
Lordship, let's see, Lordship, policy.
My learned friend's client is facing a contempt, Millard, after this. He's facing a contempt after having argued this. Millard, I mean to say his
Exceptional
clients.
circumstances where a small acquire are acquired.
No, are required.
Required in the
Are
case of
required
the
for
where the
vital works in
importance of
such
land is
cases,
this, mutually accepted such and such was bidding up for upon acquisition of such vital.
My lord, it says use. The principal policy says
Lordship,
use
now
or
we
acquisition.
argued this matter. One matter I was, what contempt he is saying about, I don't know. I am not there. So far, contempt is concerned only. I am not there. Or in the main matter, I was not there. Contrary. Contrary.
যেটা suit file
Mr. Banerjee, this 74 says with regard to acquisition, not with regard
this
to
is not Millard the sole document. That's why Millard the
That I don't know. But so far, this document.
my
is
learned
from
friend knows by
equity.
heart.
So he has
I learned-
become a very specific case. Before I answer, that even on purchase,
আমি বলি একটু my lord আমি একটা কোয়ারি করেছেন বলি
না, তুই বলবি তাহলে।
the policy says use or acquisition whatever Millard, let us allow Millard, kindly allow us Millard to bring that document
Then
a supplementary affidavit Millard within a week.
Mr. Banerjee, learned advocate,
first order which I passed and set
ठीक है,
aside.
ठीक है, the point. Huh? Vote.
I'm ready.
Same meeting. Yes, call the Passover matters. Yes, Mr. Banerjee, where are you? Matters are being called on.
Matter was going on, my
Two or
junior,
three matters called on, you were not.
my junior was supposed to be here, but he was here in the entire morning. I was also here,
Much more busy than you are.
suddenly disappeared. No, one matter, I was waiting for this
No, I
matter.
am saying your junior is much more busy than you are.
Seems so. And the junior in the panel, she has been depaneled. Junior was outed with me in this matter. She has been depaneled. Depaneled. Because of the election.
Yes, yes. Yes, Mr. Banerjee, what is your instruction?
Milord, there was a direction to file a report, Milord. Milord, I have instructed them, Milord. They have not yet furnished me the report. I am praying for a last chance, Milord. Kindly give me 7 days time. Otherwise, I'm in touch with them, Milord. They have not handed over yet. There are cases that Milord, state and
of November. Today we are on
I know,
25th
but-
of November. Till now, you could not file, take instructions with regard to whether it has been withdrawn from requisition or not.
and whether any disturbance is created.
By the state. This is the only thing I have.
I'm keeping it on second on the prayer of. Yes, call the next matter.
12, 12.
12, yes. Yes, Mr. Pan, where is your other side?
Mr. Banerjee is here.
They was appearing in this matter, but I have been engaged for Milord.
Oh, you are here already.
Yes.
Not for Milord, the other state respondent. Mr. Day is appearing. He's supposed to file a report. Milord.
Where is Mr. Dey? Mr. Dey is assisted by juniors.
Direction
Where is
to
Mr.
file a-
Anirban Sarkar?
And the same officer, Milord. The previous matter and this matter, same officer is supposed to not file the report.
Then he is to be taken to task.
Yes.
Then he is to be
Yes.
taken to task. In all matters, Mr. Banerjee, this cannot be.
Yes.
Where is he? Where is Mr. Dey?
Kindly makes it not today, but I'll.
All right, not today. Yes. Next.
Milord, 15 was also.
Hey, 16.
15,
15 passed over actually.
14.
14, I think dismissed for default. Nobody was here. Don't say Passover. It was not passed over.
I was on my leg, I just entered and whatever.
Right, 14th din, 14th din, 14th din. 14th din.
I don't know about 14, my lord. Mr. Nilotpal Chatterjee is appearing for the state, my lord. He is at present on his legs.
Is that present?
On his legs, my lord, addressing
You are
justice.
here.
No, my lord, I am not briefed in this matter, my lord.
Yes, yes, din, 14th din. Yes, start.
Lordship, the matter pertains to a piece of land, refugee land, which was the petitioner herein was the power of attorney holder of the person who had the land. Now, an order was passed recognizing a piece of land by this coordinate bench. An order was passed, representation was made, Lordship, to make this land a freehold land in her name. An order was passed to consider representation. Later on, that representation was considered and the land was made freehold. Thereafter, the private respondent's lordship had filed another writ petition challenging the quashing of that land. Lordship, we had served the private respondent. The issue is, lordship, the affidavit of service has been misplaced, lordship.
So service has been misplaced.
So, lordship, let us come back.
Matter of you have filed on August 2000.
August, lordship.
Let me see. Yes, what is
Lordship.
the what order you are challenging?
Lordship, we are challenging the impugn notice that was given, Lordship.
Yes, page.
Lordship, it's annexed to P5.
P5, page.
Lordship, annexed to P6, P9. The impugn
What
notice.
is the page? P9.
P9, Lordship.
P9 is not a notice, it's a deed.
That's the indenture, Lordship. That's the impugned indenture that we are challenging over here. It was
that-
passed,
How can that be cancelled in under 226?
Lordship. It was passed while pendency of our order that was there to consider our representation.
Can that be a ground for setting aside a deed, registered deed?
Lordship, let us come back, Lordship.
What coming
I'm,
back?
I'm,
I'm asking you.
I'm led by Mr. Devanik Banerjee. I'm led by Mr. Devanik Banerjee. Let us come back,
Pass over.
Lordship.
Yes, pass over next.
15, my lord, I am appearing for the petitions. This is my affidavit of service, my lord.
Yes.
My lord, my lord, the petitioner has applied for change of nature of use of their land. The premises used to be earlier as to be used as a karkhana.
Change of nature of use you have applied before whom? Under what provision?
Under section 4C, my lord.
Yes.
Now, my lord, we have applied. My lord, thereafter, may indicate, my lord, it was used for a karkhana, but there was no.
What are you challenging now?
Now, my lord, what has happened thereafter? Thereafter, the Deputy Secretary, Land Department has written that would appear at page 85, my lord, to consider the petitioner's application for change of nature of use.
Page 85, yes.
Yes, my lord. Thereafter, after, my lord, kindly looks at page 87, a communication dated 4th of February 2025.
Yes.
Now it says, my lord, that I'm sending herewith a copy of the letter bearing number such and such with all its enclosures as received from the Labour Commissioner, West Bengal. I am directed to request you take necessary arrangements for inspection and submission of the viability report in accordance with the SOP issued by the department in this regard from all aspects regarding conversion of the land from Bagan Bhiti Danagar to Karkhana housing complex as applicable in reason of the below mentioned. My lord, the serial number 1 is the petitioner's property.
Yes.
Thereafter, my lord, from 4th of February 2020 till date, nothing has been done. We have even written to the, my lord, the survey unit, my lord, the very next page, my lord, page 89. Not the very next page, my lord, page 89. We have already informed them. My lord, upon instruction, I say, my lord, that inspection has also not been caused.
Where is your application for conversion?
My lord, at page 81. This is more or rather of a representation, my lord, but it has been considered. Because, my lord, page 85 would disclose that they had taken
Yes, who is appealing for the state?
My lord, I have served them, my lord. The notice says that it was delivered, but it is delivered, my lord, way back in September, I find that.
Who has been engaged? Have you
My
served
lord.
upon the government leader?
No, my lord. The advocate was served upon the individual offices. I find that, my lord.
Are you not required to serve?
I know that, my lord. I thought the service was affected upon the. My lord, then kindly gives me a.
Can you appear? Do you have an extra copy?
Yes, my lord. I can give him.
A copy to Mr.
वो नहीं चाहिए.
The learned advocate appealing for the petitioner submits that the Yes.
Number 17, my lord, I appear for the petitioner. This is my affidavit of service. My lord, in this matter, it's a concerning affidavit of service. আগেরটা ছিল 15
So Bandhavata, please give the name of your junior. Who is for the state? You are appearing for the state. Yes.
My lord, in
Yes.
this matter, it concerns my land. I had purchased 0.03 decimal of land, and out of which on 0.02 decimal, I have constructed a house. The remaining land was adjoining the road. Now I find that the remaining land that had been purchased by me, road is being constructed thereupon. I made protest
Who
of
has constructed the road?
the Panchayat authority. They're constructing Moram Road on that land. I lodged protests. I made representation. Previously, I had approached the Honorable High Court. Honorable High Court directed the BDO and to make it to give me hearing and to hear out my representative, provide me opportunity of hearing and decide the matter. Now, the Honorable BDO says that
Video has passed an order.
they have passed an order, my lord.
Where is that?
I'm
That is, you
page
are challenging
66,
that
my
order.
lord. I'm challenging that order, my
Where
lord.
is that? Page
66, my lord. Can you see page 66?
Yes.
Now, he passes an order where he says that I have not been able to show that land was under my possession, and a road had been used for a road for many years. Therefore, I am not entitled to any compensation in this regard, and I have no claim on the land at all. That is the sum and substance of his order, my lord. He says, although all records show that I am the owner of this land, since I have not been able to show it is under my possession, I am not entitled to any compensation, and this has been used as a road for a long time. Therefore, I am not entitled to anything in respect of this land. As per the order, my lord, kindly see page 68, my lord. From the computer plot, page 68, my lord, lordship on page 68.
67 I am at.
Yes, my lord. That is the previous. It gives the background to the matter. And can you see from page 68? From the computer plot information, I'm saying, my lord. Has your lordship got it?
What is your name?
The petitioner's name is Ashit Kumar Khara.
But Dilip Samanto, Pradeep Samanto, and Ramchandra.
These are co-riots. These are
of the same plot
of the larger plot or joining plots, my lord. My lord, kindly turns to page 68. It will be clear.
Where is the record of rights?
My record of rights is annexed earlier, my lord. Kindly see page 60. Page 1 second, my lord.
Page.
I'll let you know, my lord. But kindly hold on, my lord. 1 second. It's at page 23, my lord.
Page 33.
23, my lord. That has the record of rights. Ashit Boron Khara is recorded as Rai. Ashit Boron Khara, Ashit Kumar Khara, same person, my lord.
Entire plot is 30 decimals.
0.3 decimal. 0.03 decimal, my lord. 03 decimal, my lord.
0.03 is your share.
Yes,
the entire plot is 30 decibels.
Entire plot is 30 decimals. Yes, my lord. I am
plot is
correct.
30 decibels. So you have with regard to 1 decimal.
I have 03 decimal, my lord.
No, where is that? 03 decimals. 0.01 decimals. That's your share in the plot.
Yes, my lord.
0.0309 is the share of the respective rats in that
Yes, my
plot.
lord. Yes, my lord.
Your quantum of your share is Land is 0.01 decimals. That's 1 decimals.
Goes na.
One
Not
decimal,
3
my lord.
decimals.
Petitioner has been constructed that, petitioner constructed of that land. He is deciding at the same plot of land, my lord.
What is the constructed area?
Constructed area, my lord. I have
What
constructed
is the
over
extent of your construction, sir? It's 1 decimals. Do you know how much area is 1 decimals?
0.3 decimal, my lord. 0.2 decimal I have constructed upon.
Sir, here record of rights shows 1 decimals.
1 decimal.
That's your share amongst the rats. 0.0309 is the share.
দাগের মোট পরিমাণ 0.3, দাগের মধ্যে
অত্র সত্ত্বের অংশ।
1
So
decimal.
it's your share in the entire property.
0.01.
This is the share of that rat in the entire property. This is not the extent of the portion which you are owning.
My lord, as per instructions of my client, out of 3 decimals, 2 decimals were not recorded in my name. I have purchased, I have deed of
That's
to that
neither
effect.
here nor there. In the record of rights is only 1 decimals. So now, what is the area of your constructions on how
On
much
2 decimals I have constructed.
So, but the record of rights shows where is your deed? Show me your deed.
My lord, my deed is annexed at page 19, my lord. Page 17 onwards, my lord. 17 onwards is my deed, my lord. Kindly see page 20 in the mid, from the middle.
Where is the entire plot information of that plot?
তপশীল এখানে আছে 21.
Yes, what is your instruction?
But I have not taken any instruction today, my lord. Next week, I shall file a report. With sketch map.
But
2 weeks, 2 weeks.
how can you sustain this order? Because it says that it has been recorded, he is not under possession. How can you say that he is not in possession? Who are you to decide the possession? Revenue authorities cannot decide with regard to possession, and said that it was long being used as a pot. Record of rights do not say so.
That's why, my lord, I shall file a report, my lord. File a report.
Report, you cannot improve upon this order by filing a report. They are challenging an order. Take instructions because you cannot improve upon what is there in the order by filing a report. Ashok. The petition. December, same heading. Yes, next. Yes, yes.
I am for the petitioner, my lord. I served upon all the respondents. Service is effective.
GP office you have served.
No, my lord. This is a national highway authority, my lord.
Oh, National Highway.
My lord.
Yes, who is for the National Highway?
Normally, my lord, Miss Monica is appearing on behalf of the, usually appear on behalf of the national highway, my lord. My lord, this is I made an application before the
Did you
authority.
serve her prior to mentioning? This matter has come up as per your mentioning.
No, my, as per schedule of the list, my lord.
No, this has come up after you have mentioned this matter.
My lord.
Have you served a notice?
After After mentioning that,
How do they know, sir?
my lord, yes, sir.
You are mentioning it's being listed. The minimum that is expected that you have to serve the other side before mentioning that you are not doing.
My lord,
Then I have to check all those affidavit of service and other things. I'm allowing mentioning, but that's the minimum thing which you have to maintain.
Kindly pardon me, my lord. Yes, sir.
The learned advocate.
Number 19.
Yes.
And I am for the private student.
19 you are for the petitioner.
I am for the petitioner, my lord.
Yes. Mr. Mahato for the state.
My lord, I am for the private student.
You are for the private respondent.
Yes, ma'am.
Yes. What is this?
This is, my lord, the unauthorized construction over the PWD land, my lord. I raised objection before the authority concerned that was not considered by the authorities. I am the owner of the.
Yes, Mr. Mahato, what do you say?
My lord, I have got instruction.
You have got inside. What is the instruction?
Instruction says, my lord.
You look on the file. Yes.
My lord, I have constructed my
There-
over my recorded land. I have Ravati land. My lord, there is.
Mr. Mahato, what is your instruction?
My lord, instruction says, my lord, there is a bamboo facing.
There is a
bamboo fencing structure, my lord.
on the PWD road.
No, my lord, it is land. And after road, there is a
land.
After road, there is a Noyanjuli.
After road, there is a Noyanjuli, yes.
Thereafter, my lord, this is the open space. In open space, my lord, kindly see.
Open space, who is the owner of this open space?
My lord, the ownership has not been mentioned, my lord, here. Yes,
Then, Mr. Mahato, this has to be mentioned.
my lord.
How can you say that?
A and B, these two parts, my lord, has been, there are the bamboo fencing. And the land of the petitioner is, my lord, the next land, applicant's land.
Applicant's land is 37.
37.
What is 37 means plot number 37.
Plot number
37.
And I am the owner of plot number 38, my lord.
That
I have
is below.
constructed, my lord, in plot number 38. This is the record of right in my.
You are the owner.
I am the
You
owner.
are saying
Private
free
student.
space. What is free space, Mr. Mahato?
My lord.
My space.
Show me that your. Show me your.
This is the record of right, my lord.
Record of right shows your name.
Yes, my lord. 38, my lord.
38.
In respect of 38, there is no encroachment. In 38, my lord, there is no dispute. This is a 424.
No, yes, 38 there is no encroachment.
No encroachment.
But 424, who is the owner or who is maintaining this 424?
My lord,
Lord, this is kindly see the photographs, my lord.
my lord,
Photographs, I cannot decide which plot number from the photographs.
No, my structure is, my lord, far away from the road. This is the photograph. My specific objection is this, my lord. I am the owner of the plot number 37.
I never encroached 37 or
In
PWD.
front of my plot 37, the PWD land is encroached and constructed by.
PWD, they have given a report, sir. After the PWD road, there is a
Noyanjuli.
Yes.
There is plot number 424 and 38 by 401.
Yes.
My
So
plot is-
38 by 401 is owned by him.
No, I am not concerned about the plot number 38.
424, what have you stated? What is your pleading with regard to 424? Show me from your writ petition.
I am not.
No, nothing.
Specific objection is the in front of my plot there is 37, my lord. There is the 37.
In front of your plot is plot number 37.
37. 37 is my plot. Page 32, my lord. Page number 37.
No, you are the owner of plot number 37.
37. I am the owner of the 37, my lord.
Yes.
Just, my lord, kindly come to page 24. Page 24, my lord. The sketch map was annexed in the deed. Page number 37. my lord.
Sir, Mahato, what have you shown by applicant's land dotted with orange color and the balance? What is the meaning of this?
My lord, here the, my lord, the sketch map. That
yes.
This is a free space, is the, my lord, the green
No,
color.
not free space. He is the owner of 37.
Yes.
Now 37, you have, it's a triangular plot.
Yes.
Yes.
Now, inside that, you have marked a dotted line with orange color.
My lord.
37, you have mentioned applicant's land.
Applicant.
So this is his
My
plot.
my plot.
Now, in front of that 37,
Unauthorized
Mr. Mahato, have you given this report to him? Otherwise, he will not be able to. Another copy you have?
Yes.
Please give it to the private respondent also. Yes. Now, please turn over to the sketch map. Now, sketch map, you have come to the sketch map.
My lord.
So, your
Plot is
property
the
is 37 is a triangular plot. Out of that, your property has been marked as orange color.
My lord.
Now, in front of that, there is a free space.
My lord.
It's part of 424. Who is the owner of 424?
PWD authority.
Where have you stated?
My lord, I am not specifically the plot number was not stated, but I am stated that in front of my
Sir
property.
Mahato, have you stated that you have only said free space, but you have not stated who is the owner of 424?
My lord,
Whether it's maintained by the PWD or not?
my lord, for a moment, my lord. The
Yes, my lord,
marked
it is
as-
not clear.
marked as A.
37, classified as Rasta Jomi. 37 by 424.
Yes, yes, yes.
Then, if it is a Rasta Jomi, it's PWD.
PWD.
With a share of such and the said area has been recorded in the name of Development Roads Department. So, in your name. So, there's an encroachment.
My lord.
Yes, and there,
If
any bamboo fencing is
Who is
there,
the A
over-
and B? Yes.
I,
Taraknath Maji.
yes, my lord. Yes,
You have made this construction.
no, no, I,
Yes, yes.
my
Yes,
construction
yes.
over 38. my
38
lord.
years you are the owner, but you have also made this construction.
Construction, if any bamboo fencing is there over the plot of PWD, I have no objection.
All right. So let it be demolished. Yes, demolished.
Yes, but I have, my construction is over 38. 38, there is no dispute.
This is indicated. They will demarcate if it is found on 424. That they will demolish this bamboo fencing.
Yes.
Because bamboo fencing, there are two structures A and B. Both your name is Taraknath Maji. Both is owned by you. You have made this construction. And you are present at the time of demarcation also.
Yes. My instruction is, my lord, my construction is over 38.
Sir. Your client very much knows. He was present.
And record of rights prepared in my name. 38, 38.
There is no difficulty on 38
Yes,
by 401. The problem is with regard to 424.
424. I am not owner of 424.
Yes, that is why let it be demolished.
My lord.
The petitioner claims to be the owner of আচ্ছা ওটা একটা করে দিন। Yes.
For the petition.
How many properties you want to demolish? Yes.
Petitioner is,
This is also demolition.
this is a national highway land.
Yes.
I am for the
So,
private response.
Getting the earlier matter. It was also the national highway.
Not briefed in those cases.
Yes.
Encroachment over the national highway land, my lord, just in front portion of the Rayati plot of the petitioner. The petitioner raised in, filed an objection, my lord, XLP 4, page 26.
Yes.
And
You
I
are
am
for the
for the
private respondent?
private respondent.
Yes. Why have you encroached?
There is no Paka structure is there.
Katta structure is there.
Private respondent number 12 and 16 are involved in this matter. Remaining private respondent have no interest in this matter.
You are which respondent?
I am all respondent.
Yes.
Their submission 12 and 16 are continue there under the polythene shed structure. No Paka structure is there. The petitioner encroach the highway.
Petitioner encroach the
the
highway.
highway road to stop the ingress and egress of the locality.
File a
And
report. File a report.
In this case, the new
You have got
notification.
instructions.
Yes, Your Lordship, the new notification which has come, the powers under section 26 of the Control of National Highways Act have now been given to the district magistrate. Lordship, may kindly.
Have you implemented?
Yes,
Yes,
Lordship.
ma'am.
Number 5.
Yes. Who is appearing for the district magistrate? Have you soft copy?
my lord, stop, service is effected.
Mr. Bandyopadhyay, why no one is appearing from the state? Please give a copy to Mr. Bandyopadhyay.
My lord, just now I have handed over my copy. I shall just after.
He has to take instructions. Take instructions. The
Mr. Tanmoy Basu is engaged in court number 30.
Who is engaged?
Mr. Tanmoy Basu.
Yes.
I'm for the opposite party, private opposite party. I'm for the petitioner, Your Lordship.
So what next? Yes, yes. 14. 14, yes, come. Dismissed for default, restored, pass over. Many things have happened now. Move the matter. Yes, who is opposing you?
Lord, the private respondents, Lordship, the
State.
state
Cannot-
was there.
You cannot pay for issuance of a mandamus upon a private party.
No.
State.
স্টেটের কে ছিল ওই ছেলেটাকে বাইরে ছিল তো দাঁড়িয়ে স্টেট ওয়াজ দেয়ার Lordship.
Yes.
Your Lordship, I am appearing for the state led by Mr. Nilotpal Chatterjee, sir.
Yes, where is he? Ask
Your
him to come.
Lordship,
Yes.
Learned Senior is engaged in courtroom number 3.
Since 2 p.m. he is engaged in one matter.
Yes, Your Lordship.
My Lord, then
Who is assisting him? You are assisting him.
I am not briefed in this matter, Your Lordship. We have no instruction. Come back with instruction.
What is this matter?
My Lord, I also need to.
You are ready. You have filed the report. Don't say you need instructions.
No, not instructions. Can I come back tomorrow, Lord?
Why?
I could not prepare myself. I will be very honest. I could not prepare
You
myself.
could not prepare yourself. You have filed the writ petition and you could not prepare yourself.
I tender my apology, Lordship. I do not usually make this prayer, but I honestly could not.
The question that was put by the court was informed to you, then you want time.
No. Because the private respondents, Lordship, the service is not traceable in my chamber. State was served. Private respondents were also.
We see whether you can cross the first hurdle.
Then
But
may I
the
come
private
back tomorrow
respondents
morning
are
and try?
Necessary to be hard.
We all will be fresher tomorrow morning. We'll try to jump the hurdles better.
All right, not today. Yes,
I'm very
yes.
grateful.
Much obliged, Your Lordship.
Call the next matter.
I'm praying for not to on behalf of the petitioner.
Don't pray for not today. Yes. Yes, what is this matter?
My lord, actually,
The
Mr.
Act is West Bengal Land Reforms and Tenancy Tribunal Act. How a writ petition is maintainable? In the presentation form, you have
My
said
lord.
West Bengal Land Reforms and Tenancy Tribunal Act.
My lord, may I be permitted to appear online, my lord?
Yes.
My lord, my lord, I do not have a copy of the brief with me, my lord. Kindly mix it not today, my lord.
Where is the order dated 12th of November 2018?
My lord, you missed the brief, my lord. Kindly mix it not today, my lord.
You are for the petitioner?
Yes, my lord.
Yes.
My lord, you missed. My lord, you
What
missed
you
the
have
brief.
missed?
My lord, order of the West Bengal Land Reforms Tribunal, my lord.
Yes, West Bengal Land Reforms and Tenancy Tribunal has passed an order. Is the High Court an executing court of the West Bengal Land Reforms and Tenancy Tribunal?
My lord, may I come back tomorrow, my lord? My lord, I do not have the brief.
What are you doing? An order passed by the Land Reforms and Tenancy Tribunal, the High Court will implement.
My lord, I will satisfy my lord to that effect, my lord. May I come back tomorrow, my lord?
And that too, the writ petition filed after more than 7 years.
My lord, not 7 years, my lord. Or
yes, 2018.
Yes, my lord. Yes, my lord.
2018
Yes.
November, 12th of November. Today we are on 25th of November. More than 7 years.
Yes, my lord.
More than 7 years. And that too, whether a writ petition before the single bench is maintainable.
My lord, may I come back kindly, my lord? Adjourns it for the day, my lord.
Section 6, 7 and 8 of the West Bengal Land Reforms and Tenancy Tribunal Act.
My lord, kindly mix it not today, my lord.
The learned Next, call the next matter.
Grateful, man.
Yes.
Well, 23, I'm for the petitioner. Well, the last occasion, your lordship directed to submit a
Where
report.
is the state?
23.
Supratim Dhar, Devobroto Kole. Yes, what is this matter?
Well, kindly come, my lord, page number 19, my lord.
19.
19, my lord. In the earlier occasion, my lord, there was file a writ petition. And my lord, in that writ petition, my lord, lordship directed, my lord, kindly come the
Copy of the inspection report. was not
inspection
served
report,
upon
not served upon him, my lord. And my lord, as per on the earlier occasion, lordship directed to serve a copy, my lord.
Where is Mr. Dhar? Ashun. The petitioner is represented by his land.
Lordship, I'm appealing for the state respondent led by Mr. Ashish Kumar Guha.
Lordship.
I'm appealing for the state respondent.
For the petitioner?
Yes, sir.
Yes.
I'm for the respondent number 9, Postal Medinpur Jilla Parishad.
Yes, what is this
Such
matter?
respondents are trying to fill up the pond with, without any permission, Lordship.
24.
24.
Yes,
Owned by whom?
Ramkrishna Naiya.
Huh.
No.
Sorry.
Pond owned by whom?
Petitioner, Lordship.
Sorry, my lord, I'm not in this matter.
You are not in this matter. Yes, who is for the state?
Lordship, I'm appealing for the state.
Yes.
Lordship, kindly come to paragraph 13 of this writ petition, Lordship.
Yes.
The petitioner is moving this honorable court as a learned tribunal is not functioning with only one administrative member, and there is
Learned tribunal is functioning with only one administrative member. Which tribunal?
land tribunal.
Land tribunal.
Land tribunal, is it so? What are you saying? Subject to correction, land tribunal is not functioning with only one administrative member.
Lordship.
Lordship, one application was made before in the court of the learned executive magistrate at Baripur.
No, executive magistrate is another thing, but you have said that you are moving this because according to you, allegation is that change of classification of a property without taking steps. So you have to approach the learned tribunal, and even if the tribunal is not functioning, whether the writ petition before a single bench will lie. And most so it's not correct that there is only one administrative member. Making it not today, madam, please take instructions.
Lordship.
Yes.
Grateful, Lordship.
Call the next matter.
Number 25.
I am appealing on behalf of the state. Well,
You are for the state petitioner. You are for the petitioner, yes.
Sir, miss the brief, Lordship. I'm praying for
All right, not today. On
Great.
the fixed matter.
Great.
Yes.
Item number 21 has been passed over. Then can it be not today? I'm for the opposite party. Item number
31.
21. Kindly then make it not today as your lordship is taking up the
Today.
fixed matter. As your lordship is taking up the fixed matter. Item 21, your lordship.
I
not-
think Mr. Bose will continue for more than 5 minutes.
I will.
Leave your place.
Yes.
And how appropriately your lordship fixed it at P25. But being in the middle of the week, since the middle of the week,
Possibly season wise, it
My apprehension was right. Yes.
that there's a difference between the council's apprehension and a judge's apprehension. But the basis of these apprehensions are different.
No, you all knew about it, but you did not express it.
No, it is not possible for us to know.
You may not be, but Mr. Chaturvedi
Yes.
knew it.
No, but some knows how many are.
No, not only for that. Mr. Chaturvedi must be knowing the real reason.
Okay.
He's only smiling. He's not saying anything.
Man, his smile says it all.
Yes, Mr. Bose.
Yeah, yeah. Look, I addressed my learned friend addressed now.
Application copy গুলো
My lord, the query that fell from the bench.
তো CPC টা দেবে না আর পার্টনারশিপ অ্যাক্ট একটু দেবে
Yes. পার্টনারশিপ একটা দাও
অপশনটাও আছে তো
এসছে পার্টনারশিপ এসে গেছে
এই তো অপোজিশন হ্যাঁ জাজমেন্ট গুলো একটা আর মোটা পেপার বুকটা Mr. Bose.
Lord, I have addressed your lordship on the issue that the appeal has abated.
Yes.
But there are certain undisputed facts. Well, there is no dispute on record, at least, that there were two at the time of filing of the suit. One died during pendency. Subsequently, during the pendency of the second appeal, the other appellant died. Now the situation is, I say abatement on one more query that fell from your lordship was, so what happened to the suit when one died out of the two
And the firm dissolved.
and by operation of law 66 Supreme Court and the 2010 2 Supreme Court says when there is a partnership of two, one dies, there is the automatic dissolution. So could I have pursued my action against the dissolved
steps
against the dissolved firm? My lord, apropos that, my lord, we've been able to what best we could gather. My lord, first I'll give your lordship. Which one should we
This
start?
query was apropos to your submissions and the decisions you have pointed out.
Yes.
That cuts against you also.
It does, it does. So, my lord, the situation has to be addressed. Now, my lord, your lordship will see. The first one, which one are we showing? Mhm. No, where is your note? The note that you gave last? Document one, yes.
Now, Mr. Chaturvedi, only one thing. Where are those partnership deeds? You have only craved leave, you have not annexed those.
No, I have in my application, Lord, I have
You have
stated,
annexed?
no,
No.
I have,
Those copies, you have craved leave for those.
no, I have craved leave, my Lord, in respect of the last of such reconstitutions, and I have specifically averred that in respect of the earlier reconstitutions, the deeds are not available.
Let us first
Not-
see
Not
70,
available.
70.
Because,
Ah,
my Lord,
70.
these are in respect of, my Lord, the predecessor constituents of the third link. Means in 2000, in 2000 when Bhimol League died, before that there was a reconstitution. Then thereafter, my Lord, two partners remained because Bhimol League died, one of the three partners.
The partnership deeds which are available to you.
My Lord.
Yes, Mr. Bose.
My lord, this Bhimol League before that reconstitution, this is completely, my lord, completely. Even this case was not even been made out in the written statement also. Anyway, my lord, too late in the day, my lord. Kindly, first is this would be, my lord. This is 1972 Allahabad, page 1. It's a 3 judges bench. AIR 1972, Allahabad, page 1. এটা জজ সাহেবকে একটু দেবেন? Give me a copy as well, though. My lord, I will eventually take your lordship to paragraph 22. Before I take your lordship to paragraph 22, my lord, kindly consider paragraph 2 once. Then, my lord, para 22 will become relevant.
Yes.
Thereafter, my lord, kindly take now para 22.
Paragraph 2, then 22.
Yes, my lord. 22 is the proposition.
Yes.
From the provisions of the Partnership Act noted above, my lord, what has been noted, if your lordship will kindly take section 48, section 46, and 41 to 44, which is the dissolution, the different situation of dissolution, what happens after dissolution, everything. Man, 41 onwards. Then, my lord, kindly come back to 22 once. From the provisions of the Partnership Act noted above, it will be clear that a mere dissolution of a firm does not bring about a complete extinction of the firm itself. The firm, even though for the limited purposes mentioned in the relevant sections, continues to exist until its affairs are finally and completely wound up. It is only after the dissolution of the firm that its affairs can be wound up at the instance of any of the partners. Till the debts and liabilities of the firm have been fully paid off, no partner can claim any particular property as his own, nor can he claim that he has any specific share or interest in any property of the firm. It is only after payment of all the debts and liabilities of the firm, there is a surplus left, that a partner can have the surplus distributed according to his rights. The accounts of the firm as between the partners have to be settled subject to agreement by them in accordance with section 48. The partners of the firm presumably are not co-owners of the property. Then it continues, my lord. So, my lord, so for our purpose, it is only relevant to the extent that, well, this is an unusual situation. Now, my lord, today, if your lordship will see hypothetically a situation that there are several multiple actions against firms. There could be any proceeding. There could be a proceeding for recovery of money. There could be a proceeding for any other action against the firm. Now, because one partner died in a two firm situation, I'm not going beyond two firm because more than two, well, that is no. I mean that there is
That continuation of
that continuation remains. So my suit will fail. So, my lord, I will not be able to recover, or I will not be able to assert my right to a conclusion because, my lord, one of the partner has died. So the liability or what I claim from the firm cannot be adjudicated in view of this. So that is why, my lord, the Partnership Act, my lord, makes out a mechanism by which till such time the liabilities are paid off, the firm is eventually not dissolved.
So technically speaking,
yes,
a suit or any proceeding by or against that partnership firm, till it is ultimately wound up, can continue.
Yes.
That's the corollary.
Yes, it is. Now the situation will become different when the second dies.
Even then,
no
firm, Mr. Because
yes,
let us for the purpose, let us assume yes, both dies.
Yes.
Now what will happen?
Yes.
Upon whom this decree will be can be executed against whom?
No,
There has
now,
to be
now,
someone. Let us take, yes, you get a decree. For the sake of argument, let us for the moment accept after the death of the second partner,
yes,
the decree in the suit attains finality.
yes,
It's only the operative decree which is of the trial court, which has ultimately been affirmed by the
yes,
first appellate court.
yes.
Now, against whom he will execute?
I will execute it against the firm.
There is no one.
No. So now the question is that,
This stage,
yes,
let us, for the present, consider a situation. Yes, the operative decree is there, appeal gets abated. Let us for the moment.
yes, yes.
So now the next stage is for execution, because you have got the decree against the firm. Nobody is there in the firm.
Now the question is, but then, my lord, that means then it will be a legal fiction situation.
That is why.
So then
So,
I have a decree in my favor. Now I have to execute the decree.
Paper decree is nothing.
Nothing. So I will execute.
Will execute.
No, because my lord, now your lordship looks at it the other way around. Because I don't have somebody to execute it against does not mean that the appeal has not abated. So just because
No, I'm not saying that.
No, I will.
I'm accepting your argument
Yes,
that the appeal has abated.
yes,
Then I say, yes, the decree is the operative decree, is
correct,
that of the first
correct,
appellate
correct.
court.
So
Because the trial court's decree has merged. Now the question is, you have got the decree. It's the question of execution.
right,
Mr. Bose, because all these things are to be considered.
correct. No,
So
you,
against whom? Against whom it is to be executed?
that
Because
means
that's important for this.
today the
Because
firm.
that is also for the purpose of continuing. Because it may be a case, yes, it has been dissolved, it has abated, but that does not take away a right of a party to apply for setting aside abatement. Or is your case
Well,
that no
till date,
setting aside abatement
well,
cannot
till
be
date,
modified?
till date, there is no party before this court
No. I'm not saying no. I'm not
seeking.
saying, but let us think of a hypothetical case, not at this case.
Very well.
So in a situation like this,
If somebody comes and applies,
so now who can? Because setting aside cannot be by anyone. So you will be getting the persons whose interest has devolved upon this dissolution. They can be only the parties against whom you can execute.
Correct.
Because this liability against the firm, this is to flow to someone,
right,
against whom he will execute.
Right.
Or it will be a paper decree.
right. So,
It will be a paper decree.
so now, my lord, the Succession Act will come in. The estate of the respective deceased will come in. Partnership has come to an end. So, if any person claims benefit to the estate of any of the deceased, he will be liable. So now, my lord, that is one aspect. Now the question is, my lord, here is a
According to you, since though technically the firm stood dissolved,
yes,
in the light of those aforesaid
Yes.
decisions, but unless and until since nothing was on record to show that it was wound up as per this,
yes.
so your suit could not have been said to have abated.
In any way, my lord, since the surviving partner was defending the suit,
That is why, though technically the firm was dissolved as per those judgments, but now the next step is to wound up this partnership in terms of the provisions of those dissolution. Till that is done, so this is the expression, does not bring about a complete extinction of the firm itself.
right?
So the firm remains.
Yes.
In
For the
eye of
purpose
law.
of yes, for the
In the eye of
purpose
law.
of satisfaction of the.
Yes,
If
so
your
in the
lordship
eye
will
of
see,
law, there is an existence of the
My
firm.
lord.
So technically, if the firm exists and you have sued the firm only,
My lord.
so your suit cannot abate.
My lord.
This is your submission with, as against Mr. Chaturvedi's submission that the suit stood dismissed.
Yes.
Oh, sorry, stood abated.
Correct. And my lord, this my lord proposition is the English proposition, which has been borrowed by Indian courts, my lord, initially, my lord, that a suit against a firm is a suit against the partners. As on the date of accrual of cause of action, the suit against the firm is actually a suit against the firm, against the partners of the firm. Well, there's a 60 Calcutta, a Queen's Bench, Queen's Bench to the. প্যারাটা দেখেছো? কুইন্স বেঞ্চের প্যারাটা দেখেছো? হ্যাঁ, দেখো। आगे 60 Calcutta था. Well, it follows a Queen's bench. Now, well, here the proposition, if your lordship will see, this is now
Sir Chaturvedi only
codified.
Though technically there is no reply to a reply, but here since he's arguing on other legal points, citing some new decisions on this,
I will.
You will be having your chance of reply, but not on facts, on these limited aspects of this.
Only. I'm grateful, deeply obliged.
My lord, before we look into the Queen's Bench and 60 Calcutta, my lord, this answer is possibly there in the Civil Procedure Code itself. My lord,
Order
kindly-
30.
Order 30.
Rule 1 and Rule 4.
Rule 1. Rule 1, in my respectful
If it is a
submission, is the
suit,
answer.
Under Rule 1,
yes.
So Rule 4 will apply. That's according
No, I'm not on that. I am saying an action can be brought against a firm.
Yes. So there are two things. Mr. Bose, you will be finding some suits, only the firm is made a party.
Correct.
In some suits, firm as well as the partners are being made a party. Some suits only against the partners. So there are ways and means of filing the suit, how you couch your reliefs and how you
But
frame
my
the suit.
after
So-
this exercise, my limited understanding said a suit only against the partners and not against the firm may not be in proper form. You have to make the firm. Now it depends, my lord. Now, if it is the tenancy is given in the joint name, then two would have been sufficient, and they bring their respective right.
Yes, because it might be
Bring-
that tenancy in respect of only, in favor of only two partners of firm constituting of four partners.
My lord, we have
Could have been.
correct. But we faced a situation like this in a loan agreement. It was an intercorporate deposit of 200 crores given to two persons, individuals. Now, these individuals were directors in multiple companies, as your lordship can understand, multiple companies, and they were two designated partners in a LLP and a normal partnership firm, unregistered partnership firm. What they did, these 200 crores they transferred to the unregistered partnership firm.
Unregistered, you have to include
Unregistered partnership firm.
the partners.
Yes. Now, when the action was brought, all these maintainability points were raised. Well, what they did, they parked the funds in the firm. So it was taken individually. So they were joint borrowers. Now, if we apply that principle here, if there are suppose two tenants, I give rent receipt in the name of the joint tenants. Now they choose to bring that the tenancy right
Now, let us
into
not
the
go
firm.
to that because it's a case here you have given tenancy.
No,
to
why
the
I'm
firm.
saying this, only to the firm.
Yes, only
My,
to the firm.
my
Yes,
tenancy is only to the firm.
Yes.
That is why possibly, my lord, whoever I am told, I don't wish to take any names, my lord, deliberately, my lord, intentionally, the partners have not been named. My lord, because the tenancy was given to the firm.
That is right. Tenancy was in the name of the firm. Suit filed only against the firm. Now, it's what is the effect? If it is suit filed against the firm, it's a suit under Order 30 Rule 1. So if it is
So
a suit
legal heirs-
under Order 30 Rule 1,
Legal heirs need not be made parties now.
Order
because
30 Rule 4.
Absolutely.
Order 30 Rule 4, the heirs or the legal representatives need not be pleaded. It can go on.
Right. And in view of the two judgments that we have relied upon, by operation of law, upon the death of one partner, it stands dissolved.
And in view of this, though the firm technically stands dissolved, but it cannot be said to be non-extinct.
Correct. Till you discharge your liabilities.
Yes.
Now, my lord, this discharge of liability thing, my lord, now you see another second situation lands up when the second partner dies. Then estate will come. Whoever gets the estate will. So, my lord, that possibly answers your lordship's query, against whom will you execute? Now, my lord, if they say that, yes, I am enjoying the tenancy by virtue of the estate, then I will execute. If they come and say that, no, then, my lord, third parties, trespassers are enjoying the property, then I will take steps in accordance with law. So this will be the situation. Now we're coming back to the
Only I have given you the example of the execution.
Yes.
Is only to apply your mind at this stage.
Yes, I can understand, my lord. That will be another. Yeah.
Yes. So
that Privy Council.
improvement is one thing.
Yes.
And so that is why I've pointed out to you against whom you will execute.
Your Lordship recollects that Vijay Kumar, Manish Kumar HUF judgment. As your Lordship must have come to know what Supreme Court order has passed. Supreme Court at the interim stage has passed an order directing all the occupants to deposit 50 lakhs. 15 lakhs. It has been settled in a week. The issue to settled in a week. They filed a review against that order also. That review got rejected. You pay 15 lakhs. The matter got settled in a week. So you are enjoying a property. So this only happens in. Of course, no. Supreme Court is now waking up to that reality. That in fact, my lord, the other judgment, it starts by saying that 50 years of litigation, because my lord, in our adversarial system of litigation, as little as I understand, well, you cannot stop somebody from filing an application. Your Lordship recollect that Ganesh got property. Yes. And the Ganesh got property. 110 Order 21 Rule 97 applications were filed. 110. Every day one is to come to an end, the other is to be filed. So, but eventually they got the property vacated.
That's it. Yes. Any other paragraph of this judgment, Mr. Bose, or paragraph 22 is the only?
Yes. Para 22.
Yes. Any other decision you want
Yes,
to
my
cite?
lord. My lord, we've come across one more decision on this issue. The last one that you gave just now. Maharashtra. Where is the Maharashtra? Lordship, there's a Maharashtra judgment. Maharashtra law journal কোথায় গেল? ये वाला देखो तो. Give. Where did I record it? Yes, I got it. No. Punjab. Where I did downloaded it. What is the file name? What is the name? I just marked it, but you kindly give me a moment.
Yes, which paragraph of this judgment?
My lord, kindly give me a moment.
Considers Order 30, Rule 1 and Rule 4.
Yes.
And
ACL. What is the one I said? The one I said carry it.
Yes,
This is the one.
You said to carry it.
দিচ্ছি তোমাকে একটা কপি দিচ্ছি document 1.
This is the judgment where
Yes,
after the death of both the partners, the heirs of the second partner comes in to file an application for being implemented.
Correct.
That was rejected only on the ground that the heirs of the other partners were not substituted. The Supreme Court says no, it cannot be done. The heirs can be allowed. Is
No, but
that judgment, Mr. Bose?
No. This is Ashish versus Narayan. Is your lordship looking?
Yes.
This is the one.
Well, this is a Maharashtra judgment, the Bombay High Court judgment. But kindly take this paragraph 11 of this judgment. Well, this makes out the distinction between other suits and an eviction suit. Kindly take para 11 once. Para 11. I find that there is a distinction in a suit for eviction vis-a-vis any other suit. An eviction suit is aimed at evicting a tenant. In the instant case,
which paragraph?
Para 11.
Yes.
Para 11. Paragraph 11. I find that there is a distinction.
Yes.
In a suit for eviction vis-a-vis any other suit, an eviction suit is aimed at evicting a tenant. In the instant case, the tenant is a partnership firm which has a legal existence. Partners of the said firm were defendants. Decree passed in the suit would therefore operate against the firm and through the partners. Then, my lord, Order 2030 Rule 1 considered. Order 30 Rule 4 deals with an eventuality of there being two or more persons who are being sued in the name of the fund, and if one of the partners dies before the institution or during the pendency of the suit, it shall not be necessary to join the legal representative of the deceased as the party in the suit. As such, though the petitioner may claim a right to file an application to be impleaded in the proceeding as a legal representative, the deceased, the same be required to be gazetted. Now, this court has dealt with an identical situation in a judgment dated such and such when defendant number 2 in the very same suit had passed away. Issue that was considered was as to whether the suit would abate against the deceased defendant number 2. This court upheld the view taken by the trial court in rejecting the prayer for abatement under section such and such, thereby concluding that since the firm is a tenant and merely because one of the partner has died, the suit would not therefore abate against the partners, since the decree is to be passed against the firm which is a tenant. Calcutta, have you found out the relevant portion?
Paragraph 7.
Just give me 2 minutes.
There is a distinction, Mr. Bose, in this.
Yes, madam.
Here, the tenancy was in the name of one of the partners.
Right.
And here, the firm as well as the partners were impleaded as defendants in the suit. So it's not the case as in this.
May not
Here-
be. What
here
I'm
it is
saying,
only- Here it is only the firm which has been impleaded, partners have not been impleaded, and firm is the tenant, not any of the partners is
no,
the tenant.
I am only addressing your lordship's query to the extent that when the tenant is a firm and the firm dissolves, would the suit abate or
Here
not?
It's not a case of only two partners.
Yes,
Because there are many more partners.
Yes, yes.
So two was one of the partners. That is why that distinction.
No,
So,
if you,
Mr. Bose, there will be no difficulty if there is more than two.
yes, yes, I am not on that.
Here is the case of more than two.
Madam, if your lordship kindly once again considers para 13,
Para?
para 13, 1,
Yes,
3,
yes, paragraph
where
13.
an earlier judgment has been considered
Yes,
of the Bombay High Court,
yes.
this court has dealt with an identical situation in its judgment in such and such when the defendant number 2 in the very same suit had passed away.
Yes, Mr. Bose, paragraph
my lord.
13
Yes.
refers to another decision.
Yes, it
Paragraph
does.
14 onwards
Yes.
says what was held in that decision.
Correct, correct.
Paragraph 2 to 7.
Yes.
There you will be finding that that was a case where there were more than two partners and the partner was the tenant and firm as well as the partners were impleaded as defendants.
Right. No, my lord, I am only saying that if the firm is only the party to the suit, and during the pendency of the suit, admittedly, one out of the two dies. So the principle, the same principle will apply. Because, as I showed you in the previous judgment, in view of the other provisions of the Partnership Act, yes, I'm saying.
It is all right, but
Yeah.
this is something different.
Yes, very well, my lord. All I am trying to say is that
This is has some distinction. Has some distinction.
because of the other partners, we were
Yes,
party
other
to the
because-
suit. Yes, yes, I can
If
understand.
if there is more than two, Mr. Bose, that situation will not come. Dissolution of the firm concept will not come.
No,
here.
will not come, will not come.
Because we are now concerned with the dissolution of the firm. Otherwise, more than two, Order 30, Rule 4, it can continue.
So, my lord, so far as that is concerned, my lord, my respectful submission is that, my lord, the provisions of the Partnership Act makes it abundantly clear that till you discharge your liabilities, you are you are liable and the proceeding can be continued against the firm till you discharge the liabilities. Well, bringing an action and defending an action are two different things. Because if your lordship will see, 45 says dissolution, your eventual dissolution can only happen once you pay off your liabilities, creditors, everybody, settle the dues, the remaining has to be distributed in the profit sharing ratio between the partners. Only then, not otherwise. Otherwise,
difficult to realize those. Now the partners, nothing, nobody is there. The heirs and others will wash off their hands and say
yes.
nothing, whatever has
So
been
everybody
done.
will take 100 crore loan, then say, I can't pay, sorry. They are died, I don't know what happened to
They
them.
will be the beneficiaries of the assets.
Yeah.
But they will be saying no liabilities you cannot realize from.
Absolutely.
So that is why those provisions have been made.
Now, my lord, for that proposition, would it be your lordship pleasure? Because a suit against a firm is in fact a suit against the partners.
That's well settled.
Very well. I'll not trouble your lordship. I'll not trouble your lordship with that.
Want to cite because
No,
you
I
can
mean,
cite a decision, Mr. Bose. I cannot stop you because
না আমি এখন তুমি যদি বলো at your risk I can show because I haven't read it.
Because after all, it's an interesting issue which has cropped up.
It indeed.
It's an interesting issue. You started with one issue.
Yes.
A very, very debatable issue. Now you have come up with a much more debatable issue now.
Well, let this be decided. Let this be the first judgment.
No, that is why I'm saying that you
At least Calcutta High Court. Now Calcutta High Court is a complete backstage. There was a time when we were in the front. So your lordship judgment will now rule the. I mean, this will apply to the rest of the country. Everybody will follow this now.
Nobody knows what will happen there.
Whichever way.
No. I'm not saying
There will be a decision.
Yes. Whichever way it goes, nobody knows what happens.
Nowadays, when we see nobody reads AIR anymore, everybody is gone to SCC. AIR judgment, nobody is reading nowadays. Very unfortunate. Your lordship will see Calcutta and Bombay, which used to be one volume, practically, technically, almost. Well, it has gone to not even 10 pages.
Calcutta?
Yeah, Calcutta.
That's probably because they are saying the number of volumes, some judgments are so voluminous. So I'm thinking that.
Well, that sounds
nowadays, Mr.
more like an.
With this online things, nobody is caring with those Bombay Calcutta volume and those.
No, in any way, they are the ones who's getting online.
Told
even the reports are
the AIR online version. Those head notes and other things, they have made it very easier. That's
very
what I have, very user friendly. AIR online, those versions.
But Supreme Court still head notes are still not allowed to be placed in Supreme Court, especially after that.
And they have said that the search engine and other.
Very good.
They have also been improved in AIR now.
They have. Even that INSC, which Justice Chandrachud had introduced, INSC, immediate in a matter of a few minutes, you can get that uploaded. The moment it gets uploaded, it is available on INSC. Yes. So even INSC has become for immediate judgment. When your lordship said that judgment, the nullity judgment, we took it out from INSC.
You have got that?
No, we've got the other two. We are getting the other two.
Diluting that. Have you got that?
No, my lord, we are getting the other ones.
I think that's in live law. Any one of you have
No, we all have live law. All have live law subscription. But the question is that the one that your lordship is saying, that Calcutta view has been reversed.
Diluted to some extent.
But that we are not getting.
Was that even if it is in ignorance of the death, though it is not your case here.
No.
Because you are aware of those deaths and other things. So it's not a case of decree passed in ignorance. Now, that was, even if it is a decree passed in ignorance, that will be a nullity. And it has to be relegated to the stage where the abatement took place.
Right.
I think somewhat it has been diluted.
But we'll still check, Malad, if we come across that.
I also
Malad, does it refer to Calcutta? It does. Then it will be easier to find out. Just see, it refers to 70 Calcutta.
I think it was referred, even if not referred with the decision, the principle was referred to.
So, my lord, there is a Supreme Court that my learned juniors have found out. No, but I haven't read it, so I cannot hand it over to your lordship, my lord.
For
So,
what proposition?
for some of same kind of proposition, by the time Mr. Chaturvedi addresses your lordship, my lord, if it is of any relevance, I'll give it hand over to your
Any
lordship.
other decision you
Nothing.
want to cite?
Nothing. Show me which part of that. So if there is anything, I will just indicate.
You've concluded.
I
Otherwise,
have
you have
I have concluded. Otherwise, I have
Yes,
concluded.
Mr. Chaturvedi. Only the partnership deeds, the latest one.
Yes,
and
Milord,
the-
it's coming, Milord, it's coming.
Please give a copy to Mr. Bose also.
Yes, yes. But may I, Milord, kindly give me, Milord, one moment, Milord. May I first look into it, because this is for the first time that I myself am looking at it.
Before giving it to me, please give it to Mr. Bose first.
My lord,
because he has
my
also
lord.
to-
একটা copy দিয়ে দাও।
Is the two copies of no দুটো আলাদা এটা দেখো
And Mr. Bose, are you insisting on a supplementary affidavit annexing on these partnership deeds? If you insist on that, I will ask Mr. Chaturvedi.
Well, my lord, the first date I am looking at appears to be dated 6th of October 2023. So it is of absolutely inconsequential. 23.
Yes.
And the other one is 22. So, my lord,
22.
the gentleman died in April 2021.
No, apart from that, if you want insist on, then I have to ask them to file these documents by way of a supplementary affidavit.
Well, in any way, these are
insist on
these are
that.
photocopies.
The photocopies you are having, but if
No.
you insist on
So if at least they have to produce before your lordship the original. And my lord, in any event, if your lordship will see, since there are 23 and 22.
all right, let Mr. Chaturvedi also look at it, because
Yes,
he also
yes,
says
he
that
hasn't also haven't
looked at it.
I just looked at the dates.
না, এটা রাখো, এটা পরে দেখো। Lord, Lord, I remind myself that the suit has been filed in the name of a firm. Neither in the eviction notice nor in the plaint, the name or the number of partners can be anywhere found. Neither in the eviction notice nor in the plaint. The name and the number of partners of the firm are to be found. Lord, my specific case is that at all point of time, notwithstanding a partner dying, there were at least minimum 2 number of partners. So all the eventual, all the judgments that my learned friend has shown, apropos the status of the firm getting altered, leading to a dissolution of firm and leaving behind liabilities to be owned by the surviving partner in the name of the firm, they would not be rendered irrelevant.
So where, Mr. Chaturvedi, where is that specific statement that at all relevant point of time, there were at least 2 partners?
Yes.
In your application or in the affidavit?
May I indicate? Milord, my learned junior, Milord,
All right.
would indicate in
All
the
right.
11 আর opposition
Yes.
দুটো টিপ একবার দুটো একবার scan করে দাও।
Yes.
Now, I made this submission, Milord, while replying to Mr. Bose's arguments, that this is my specific case. And when I said that, assuming for the sake of argument, that in 2000, one of the 2 partners, he died, but the firm was carried on by the other surviving partner who took over the liabilities, and hence the suit continued. But that is a point, Milord, where I joined issue.
Only one thing stopping you for, no, in 2000, the first partner died. So at that point of time or prior to the death, there was 2 partners. There is no dispute on that.
No.
As on the death of B. Mollik or
There were 3 partners.
As on the date of B. Mollik, there were three partners.
This is, my lord, this is my specific case. That at all
Where?
My lord, I shall show.
In the application.
Yes, yes.
All right.
Because this issue never came up, my lord, before the trial court in evidence. Not required. Not required. Although the name of the other partner is found in the pleading to be a subtenant.
Where?
My lord, in the plaint.
In the plaint.
In the plaint. I shall indicate. I shall indicate.
All right. So according to you, though they have described your other partner as a tenant, subtenant, he was the tenant, he was a partner of the firm along with P.N. Mollik and B. Mollik as on the date of death of B. Mollik.
Yes.
This is your submission.
Yes, yes. The kindly sees, my lord, what is the perception of the plaintiff. He says that on the date of institution of the suit,
there were two partners.
There were two partners. If I see anyone else occupying a table there, I say that you have subletted. Lord, am I clear to my lord? My case is that what you call to be a subtenant is actually a partner of my firm whom you recognize as a tenant, and he is one of the persons.
Recognizes that not a tenant, subtenant.
No. The firm.
Oh, yes.
So he is the he is a constituent
partner of the firm who is the tenant.
Yes. So he is a constituent of the firm, and as such enjoys all the rights and privileges of the firm as a tenant. Whatever rights and privileges the firm has as a tenant, Lord, is enjoyed
as a partner thereof.
As a partner thereof, because partnership is compendious of names. Now, if what my learned friend Willard insists to be correct, and I assume it to be correct for the sake of argument, that there were only two partners when the notice was issued, he may be correct in saying so. That was in 1995.
1995.
The notice was issued.
And suit filed on?
95.
95.
He may be correct in saying so.
It's the 56 Act suit.
56
yes,
Act.
56. Not 97.
No. So, tenancy rights.
Going by the, yes. It's
tenancy rights.
97.
Heritable, non-transferable. Now, I come to that. I need not go that far. Now, he may be right in saying so, that whom I recognize in 1997, they are not to be found anytime when one of the partner dies, thereby leaving behind only one person. Any other reconstitution after the ejectment notice is of no consequence. Then on facts he may be correct. But there is no law to support that if a suit is filed against a partnership firm, the partnership firm, notwithstanding any contract between the partners, cannot reconstitute itself.
What is the effect of reconstitution?
Yes. But a reconstitution is an eventuality permitted by the contracting partners in the event of a death, a retirement, or even in usual course of business.
Maybe addition also, existing partners may also think to include another partner.
So, in the case of an eventuality or in usual course of business.
What is the effect of this reconstitution as on the firm?
Right. Now, the moment there is a reconstitution, Milord, the firm, Milord, it remains to be same. The person comprising it, Milord, the compendious, it expands. Nothing more, nothing less. Now, I say that if, Milord, a firm, let us consider the same one, P.L. Mollik, Milord, it did not had anyone. Both the partners had died. Milord, I say the quest or the query should be to find out as to whether it's the right of the party sued itself exists or not, and whether it is being represented or not. Then we come to the right, whether it has a right or not. First thing is to find out whether it is being represented or not. The answer to that is that yes, it is being represented.
Who will represent, Mr. Chaturvedi? There are two things. If there are two, because you said that if it is his, Mr. Bose's argument is assumed to be correct, that there were only two partners, and one of the partners died during the pendency of the suit. Now, some decisions have been, some authorities have been cited by Mr. Bose to say that the firm dissolves.
Yes.
So if it dissolves, then who will represent the?
Well, then I need to come back to what Mr. Bose's argument is, and which I assume to be correct.
Yes.
So I first will not proceed on the basis that there were only two partners, and one of them, B. Mollik, he died in 2000.
When the suit was pending.
When the suit was pending. And no reconstitution is taken recognition of at this moment. But in that event, my lord, the firm dissolves because two or more persons are required. Now, for what purpose, my lord, the firm, my lord, still survives?
For being wound up.
Only for the purpose of being wound up, and in a proceeding where the firm has incurred a liability. But in a dissolution, one of the judgments cited before my lord, 71 Allahabad, possibly relates to dissolution. Kindly sees what questions have been formulated in paragraph 1.
Yes, paragraph 1.
Whether the document is a dissolution of partnership come 3 mortgagee come 3 releases as contended by the executant, whether the document amounts to dissolution of partnership. So this related to, my lord, dissolution of partnership. My lord, I need to have a scrupulous look at this judgment. I believe when Mr. Bose is citing it, this will be of some relevance.
Yes.
But to what relevance, my lord, we need to see in the context that we are confronted with. My lord, one partner, my lord, dying out of the two, dissolution happens. Let us now only, my lord, say that this is not an eviction suit. In that event, if it is a suit for dissolution of the partnership, not the heirs of the deceased partner, they would be entitled not to seek a share. This is, my lord, a suit for eviction where the decree, if passed, my lord, is inseparable, and hence, my lord, if the suit, my lord, it abates on the dissolution of the firm, then it abates as a whole.
Now, before going to the abatement, let us take a step before that. You as a plaintiff want to prevent that abatement. So abatement will take some time from the date of death. So the suit, even if it is accepted, your argument that when one of the two partners, if there are two partners, one of them die, there's a dissolution of the firm as well as the suit stood abated. Now this abatement will take place unless an application for substitution or steps for substitution is taken. So it will take effect after 90 days, not before. So for 90 days, this suit will remain as it is.
I'm sorry. One judgment cited before my lord, is on the premise, where the application, my lord, for substitution was rejected, saying that the suit has abated, this notwithstanding the fact that 90 days had not elapsed.
Now the question is, in such circumstances, who can represent the firm? Because the persons who can represent the firm, they can be only substituted. So let us come back to a step before the abatement.
My lord.
So who are the persons under such situation who can represent the firm? Now, because it's the question of representing the firm.
Yes.
Even if we abatement may occur if no steps for substitution is taken.
Yes.
So for that, we have to know first who can represent the firm
Now, my lord,
for preventing it from abating any proceedings, either suit or the appeal, whichever way you may take it.
yes. Now, my lord, kindly see, my lord, had this been a suit where the names of the partners was disclosed and they were being sued.
Not disclosed. Let us take this case. Only two names are coming up from these certain documents.
Not in neither in the plaint nor in the eviction
Some
notice.
documents, trade documents, we are proceeding that two names are coming.
Yes, but my lord, kindly
One died.
kindly see the framing of the suit. I am on the
One.
framing. Framing of the suit is only firm.
Yes.
Not even in the pleading, the name of the two partners is coming.
Nowhere is there. Yes.
It is not coming. So the intent of the plaintiff is to sue the firm.
Yes.
The moment it comes to the knowledge of the plaintiff that the person whom I sued has lost its status
As a firm.
as a firm, the onus lay on them
Yes.
to blood reframe the suit and proceed against blood this firm which is carrying on business in the trade name of PL Mollik, represented by now the surviving partner to be called a proprietor. This is the effect of the.
According to you, so it has to be an amendment or taking steps by them.
Yeah, one of the judgments take note of this. I shall indicate.
All right.
Now, but I am at the moment on the framing of the suit by the plaintiff as it is, and the responsibility lay on the plaintiff. But they did not do so. I say if there was an abatement, the abatement has to be at the stage of suit. If you accepted that the firm continued with its status, because all through PL Mollik has been represented to be a partnership firm. Even in the first appeal, you did not take any objection. In the plaint, you did not take any steps. In the first appeal,
carriage of proceedings with you.
No, objection that the appeal is not maintainable. Then, but why? The answer has already come. Because they say that at least one partner was alive until 2021. So the carriage of proceeding lay on him. I am on the admissions at first.
Yes.
What is their perception when they institute the suit? What is their perception when the suit is continuing? So according to
the death of the second partner.
Till the death of second partner. So till the death of the second partner, the firm was being effectively represented by the other partner. When the other partner dies, then the firm dies. Not before that. If that is what
that stage has come in second appeal.
That is what they are saying.
Yes. What is your answer to that?
Yes,
yes. In second appeal, the other partner has also died.
Yes. Now, my answer to this is kindly see the framing of the suit. Can it be said that the
of the suit is against the firm?
Against the firm means it is a suit under Order 30 rule. What is
Order 30 Rule 1? It's a suit framed under Order 30 Rule 1.
Right.
Order 30 Rule 4 will apply.
Rule 4 will apply. So Order 22 Rule 3 has got no manner of application.
So who will proceed with the suit?
I'm coming to that. I'm coming to that.
Or proceed with the appeal.
Because today we are confronted with, Milord, abatement. I have to, Milord, only satisfy my Lord's conscience that abatement would not come into picture because Order 22 and Order 30 Rule 4 cannot dwell together. I have to show to my Lord that once the reconstitution has happened and there were at all point of time more than two partners and death of one of the partners, it left behind a duly constituted firm which was operational and which was to the knowledge of the plaintiff who acquiesced.
So those are on facts that you have said.
Yes. So if that be so, then there is a devolution of interest in terms of Order 22 Rule 10. And this devolution has been accepted by them when they enforce a right of enhancement of occupational charges against these persons. But I put a question to myself. But I have suffered a decree. I, the firm, have suffered a decree. So I am in illegal possession according to the decree holder. If I am still occupying it, I am liable to be saddled with occupational charges. I was saddled with occupational charges. They say that I want enhancement of occupational charges. Now, whom do they enforce this against? Against a firm. That was the application which was filed in 2024. At that stage, they did not say that ask them to vacate. I don't want any enhancement. Ask them to vacate. In 2021, it has abated. There is no one to contest. They did not do so. They asked for enhancement at the rate of market value. Unsuccessfully here, went to the Honorable Supreme Court. Supreme Court did not interfere. Now, I suppose when this point was available to them that the firm has resolved, they could have taken this point at any point of time until the Honorable Supreme Court.
Now also they can take this.
Well, they can take it anytime. I again say, they can take it anytime. I say, against whom were they enforcing their right of occupational charges?
The other two partners, Mr. Prior to the death of the last partner is PN Mullik. Last partner is
PN.
PN.
The original PL Mulli is
a farm, trade
farm, Pannalal Mullik.
Yes. So now PN Mullik was the last partner out of that two.
According to Mr. Bose.
According to Mr. Bose. According to you, prior to his death, the other partners were there. Where is that partnership date?
Prior to
the date of
2021.
2021. Prior
Yes.
to the date of PN Mullik,
My lord.
other partners were there. Where is that partnership?
Yes.
Huh? Because Mr. Bose says everything of 2023 or 2024.
Yes, my lord. May I?
My lord, may I just give this factual correction? What my learned friend said. It is there in my eviction notice and the reply to the eviction notice. What is now been said is inconsistent to the reply to the eviction notice.
I come to that. I come to that.
Yes.
I am on their eviction notice.
Given a copy to Mr. Bose, that deeds.
Deeds, my lord, I have.
Yeah, these two.
You have given.
I have.
No, he says that it's post.
Yes,
the
yes.
date.
One is of 2022 and the other is of 2023.
So not prior to that. So at that point, at one point of time, there was no partner.
No. There, he may say so today, but on affidavit he has said something else.
No, deed. Please show me the deed.
Oh, the deeds, my lord. Today, my lord, I could. Today, my lord, I could, my lord, only, my lord, since my lord has asked for it, my lord.
You have grave belief, Mr. Chaturvedi. This is your stand.
Lord,
all along there were two partners you must be having, and you have said that partnership was reconstituted. You must be having those.
But the
documents.
last of the two deeds, my lord, were readily, my lord, we have kept it with us.
That is after that.
Before that, they have admitted, so my lord, I did not care to.
Eviction suit proceeding from 1995. You are facing a eviction proceeding.
Necessary. Those deeds are necessary. You may not be having today. You may not be having today, but
yes.
Yes.
Now, my lord, if I am, my lord, required of, I will definitely produce.
Yes,
but why I did not care to? Mr. Bose, my lord, is on his feet.
Because of his admissions.
I say, if what he has admitted, why need I trouble my lord, to look into it?
Even Order 12, Rule 6.
My lord.
Court can, even facts are admitted, the court can very well ask you to.
Yes. I say that if my lord is
facts.
Yes.
Even apart from admissions.
Yes. My lord, if my lord requires, my lord, irrespective of what are the submissions, I have to. I say, until now, why I was not vigilant, my lord, my answer is.
All right. So ask your
junior to look into it.
And the copy has to be given to Mr.
Yes. My lord, advance copies will be, my lord, served. If I, my lord, am able to trace it in the meantime. So, my lord, if the suit, my lord, if the suit according to Mr. Bose, it abated only on the death of the second partner, I put a question to myself as to what happens to the Partnership Act, which provides for that a partnership firm can only exist when there are two or more partners. What status was this firm enjoying since 2000 until 2021, for this long 20 years? What was the status of your tenant? Because the PW1 in 2001 has admitted that yes, I am aware that B. Mollik has died. In April 2002, but the DW1 has stated that one of the partners, B. Mollik, has died. So at that stage, during the pendency of the suit, you knew about it. According to you, since you are making the submission before the court, that the partnership, it survived, or the proceedings survived, notwithstanding the death of another partner in a situation of two partners, I put a question to myself and to the proposition which is being propounded before my lord today, that a partnership survives even if there is one partner. I say, what status do you confer on such a partnership?
What is your answer to Order 30 Rule 4 then? Order 30 Rule 4. Please take up Order 30 Rule 4.
Yes, Milord, I have seen. But the
Please see again.
Milord, I have seen, Milord. But
what does it mean? What is the effect of Order 30 Rule 4? What
Wait.
does it say? Please place it slowly.
My lord. Notwithstanding anything contained in Section 45 of the Indian Contract Act, where two or more persons.
Yes. So there are two things, two or more. So let us for the present, so it's disjunctive. So let us for the present consider only two partners. Leave aside or more, then proceed. Where two
or more persons may
for the present remove or more because disjunctive.
Yes.
Where two persons
sue.
Yes.
Or be sued in the name of a firm under the foregoing provisions, and any of such person dies.
So out of two,
one dies.
One dies.
Yes.
Then
whether before the institution or during the pendency of any suit, it shall not be necessary to join the legal representative of the deceased as a party to the suit.
What is the meaning of this?
Yes.
So it says,
This-
subject to correction by you,
My lord.
Order 30 Rule 4, even if there are two partners, one die, there is no necessity to substitute. Suit can continue with one person. That's the effect, subject to correction by you, of Order 30 Rule 4.
Yes. This eventuality happens when
that happened during the suit.
This happens only
suit. Two
This
partners.
Yes.
One died, so the suit can continue till without being substituted as per Order 30 Rule 4.
This happens when, my lord, two persons are sued in the name of the firm. Now, kindly see, my lord, the framing of the suit. Are two persons being sued in the name of the firm?
Yes.
Now, kindly see that.
Two or more persons be sued in the name of the firm.
Kindly see the plaint. Are two persons sued in the name of the firm?
Mr. Chaturvedi, do you have any authority to say that if it is sued in the name of the firm, not the partners, Order 30 Rule 4 will not apply? The decisions are otherwise.
No, I am not saying that. I'm not.
Even if it is sued in the name of a firm which has two persons, so it's two or more. So there are two persons can sue in the name of the firm, or
Yes.
it can be sued in the name of the firm. So suit is in the name of the firm. Even then, if one person, one of the partners dies, then it is not necessary to substitute that. So technically, a reading of it implies suit can continue with one partner.
I said this. Order 30 Rule 4 was cited before, my lord, by me.
That is why.
To counter Order 22. I say.
But so to counter your contention that the suit abated, suit will not abate in view of Order 30 Rule.
My lord, I am saying that the moment my learned friend says that Order 22 Rule 3, my lord, is applicable, it presumes that my learned friend is saying that the partners individually were sued in the name of the firm, and hence the substitution should be carried out within the period of 90 days. Since I did not carry on the substitution within the period of 90 days, my lord, my appeal abated. This was, my lord, this is the long and short of the. I say that if you are saying Order 22 Rule 3, then I say that this happened long back when B. Mullik died. Insofar as my appeal is concerned, I need not take any steps because I am protected by Order 30 Rule 4, two or more persons.
Still, P.N. Mullik was living. If we take, there were only two partners. Till P.N. Mullik was living, this would continue. No difficulty on that. That can save Mr. Bose's suit. That can save your appeal till the death of P.N. Mullik.
Yes.
So no difficulty on that. If this is accepted. Now what happens when P.N. Mullik dies?
When
For the moment, if it is assumed that there were only two partners.
Yes.
The last of the partner dies.
Yes. Kindly
Now,
take.
Order 30 Rule 4 is silent after that.
Yes.
It says only one.
Yes.
So remaining one will be there.
Yes.
So what is the stage after that?
Yes. Now kindly see, my lord, what are the facts in our case? Our facts are that this existence of more persons than only P.N. Mullik is an admitted position. Why do we then unnecessarily strain ourselves to presume a factual situation which alters the texture of the case than looking into the facts of the case, attending the circumstances which directly lead to a definite result? What is a definite result? That in 2010, plaintiff admits that P.N. Mullik has retired and hence does not address it as a partner, but addresses the reconstituent partners of the firm, thereby admitting that the firm has been reconstituted and P.N. Mullik now represented by the partners who are named in the notice of contempt. If that be so, then I am covered by.
You are covered also under Order 30 Rule 4.
Then I am covered under Order 30 Rule 4. So, Lord, Order 30 Rule 4 was initially cited by me in reply, not by Mr. Bose.
No.
Because Mr. Bose's specific cases abatement, in my understanding, that is governed by Order 22. I say the moment you say Order 22 means individuals being sued who were carrying on name business in the trade name. So trade name is being addressed automatically. Compendious of persons, the partners are being sued. First person dies. If you go by two persons being sued, then the onus lay upon you to substitute the moment an eventuality of death happens.
He is protected under Order 30 Rule 4. That is why I am trying to make it. If it was on two persons, one died, then Order 30 Rule 4 protects him.
I have
till the death of P.N. Mullik.
I have followed. Kindly cease. I am again saying, possibly I could.
According to you, the factual scenario is a different thing. Also.
Yes.
That I followed. So for that, you have to show those factual scenario. One, you have showed these admissions in the contempt application, contempt notice and other things, but the deeds. And anything with regard to this reply to these decisions you want to say?
I need to. Only one last thing, apropos Order 20, the interplay of Order 22 and Order 30. The moment, he says that my appeal abated because it is covered by Order 22. I say that means you are admitting that the suit was against the individuals, although
Order 22.
Abatement or else doesn't happen.
Let us for the moment, if Mr. Bose's submission is accepted, for the moment let us keep it aside that there were on facts there were more than one partners. In a case of this nature, if there were two partners, one of them died during the pendency of the suit, and the other died. So suit could continue under Order 30 Rule 4. Your appeal, you could have also filed appeal under Order 30 Rule 4. So, but what happens if that person dies? What is the effect? What is the stage after that?
Milord, I am only, Milord, putting these questions to myself. Milord, are we
So
real?
it has to be abated, or what will be the effect then?
Milord, if the reconstitution was not admitted,
No, for the present, let us keep aside the reconstitution. That is what I am saying. You have said that in reply to that, you have said abatement. In a case where Order 30 Rule 4 applies, there were only two partners, one died during the suit, other in the appeal. What happens next? No further steps, no one, no other partner, no reconstitution. Let us take a hypothetical case, not your case.
Yes.
What happens then? The suit or the appeal, whatever it might be, has to end.
Milord, if my lord is seeking an academic answer to a hypothetical situation, I would say if there is any person who is contesting the claim of the plaintiff, then
person is to come under such capacity.
Right.
Yes.
Number
If he
one.
comes, no difficulty on that.
Right.
Unless he comes, what is the effect? Because let us take a case, nobody comes.
Right. So this is second hypothesis that all.
Yes, because in your case, nobody has applied prior to Mr. Bose saying. So according to you, the partners are there, let them continue.
Milord, I kindly perceive this. If somebody is before my lord would, Milord, assess whether he has a right to contest the proceeding, means a right to be before my lord.
Yes.
Now, my worst scenario case would be that this reconstitution has led to further subletting.
Led to
further subletting.
That is the issue, Mr. Bose. Mr. Chaturvedi. What is the effect of a reconstitution? Reconstitution may be permissible, but what is the effect of reconstitution? He will be getting very many judgments on subletting.
Yes.
What is the effect if the partnership is reconstituted by some other partners, but the original partner remains? So it can continue. So there are other issues. Let us not go into that. Whether it will be a subletting, whether that can be a ground of eviction, that's a different thing on merits. Let us, for the present, first, whether you can proceed with the suit. If it is allowed, if it is a subletting, a decree may be passed, that's a different thing altogether, because on that factual things are to be gone into, possession and other things, control, those are to be gone into. Let us not go that far in this application. So now what are the decisions? What do you want to say? Any decisions you have?
Milord, decisions, Milord, today, Milord, my friend has cited.
পার্টনারশিপ ফর্মেশন রেজিস্ট্রি পারসন অর্ডার 30 রুল 1 টা পড় এখানে বলা আছে পার্টনারদের নাম বলতে হবে ওকে চাইতে হবে তুই বাড়িতে দেখে আয়
না দেখা আছে তে আবার এই Now, Milord, today Mr. Bose, Milord, has cited some judgments in reply.
Only one judgment.
No,
two judgments.
Two judgments.
The second
two judgments. Milord,
কোর্টস কোয়েরিটা আমরা উত্তর দেব
then I need to, Milord, reply to the honorable court's query.
What query?
Milord, what would be the status? Milord, I can in short, Milord, say that if a suit is filed in the name or against the firm,
63 ছিল না
Milord, kindly sees, Milord, Rule 1 of Order 30, and names are to be furnished.
Yes, to claim.
Rule
1 টা পড়া
হ্যাঁ ঠিক আছে জসব জানেন জসব
তো জানবে
আমি আজকে বলছিলাম না যে একসঙ্গে ওটা বলা হতো তার ভালো হতো
কালকে বল না
আমি কালকে থাকছি না
কাল থাকছিস না সোমবার বল
মঙ্গলবার
বল
জানাচ্ছি
No disclosure. The two is disclosure of the name. One does not say any two or more persons claiming to be liable as
party names,
partners.
addresses of the person who were at the time of accruing the cause of action, the partners in such firm, to be furnished and verified in such manner as the court may direct.
No, where? Which?
Any two first start
Yes,
from the
yes.
suing of partners in name of
And any party to a suit may in such case apply to the court for a statement of the names of the addresses of the persons who were at the time of
apply for a court statement
will be furnished and verified in such manner.
The partners, if the suit is fundamentally defective because partnership firm is not a juristic entity, how can you maintain a suit?
today what is being
This is a right given to any party, they can come and say.
I say
So for that, I cannot say that yes, even since they have not applied for furnishing the names, suit has to be dismissed.
I am
Because it's a right given to a party.
Why
That
why-
could have been said. Because
why I am
Mr.
saying-
Bose could have said yes, to know who are the real partners, he could have taken these steps. He has chosen not to.
if he has chosen not to,
Then what is the
then
ramification? Sorry.
ঠিক আছে. If he has chosen not to, then can he today still say that at the time of institution there were two partners and these were the two partners? I say, what is the material on record to indicate this? We can look at the plaint because he will succeed on his plaint case. What is his plaint? Well, I was thinking, Lord, to elaborate on this on the next occasion.
How much time?
Lord, about Lord, an hour in total to Lord, because if the deeds come, then I need to Lord, show that to my Lord, the reconstitutions. Then
That will take 5-7 minutes.
Lord,
before
distinguishing
the clauses.
distinguishing all the judgments that my learned friend.
He has cited only two. The other judgments.
Well, he has cited. No, he will not get any chance anymore. No. I am in reply in my application CAN 12. In his application, submission, reply
Yes, Mr. Choudhury,
completed.
That is, I have said that this is an issue. He has
Correct,
also made
absolutely.
some things in reply. Some points they have made, legal points. They have also cited decisions.
No, I shall be Lord.
Not that strict on that. There is no reply to a reply.
I shall try to be as short, Milord, as possible. Milord, I. যশোর যতক্ষণ শুনবে না কোনো অসুবিধা নেই
দর্শক শুনতে চাই বলছেন যে সংক্ষিপ্ত কর
হ্যাঁ
সেই জন্য আধ ঘন্টা বল
From my side, as long as he wants, I have absolutely no objection.
No, both of you may say that
No, of course, of
both of
course.
us will take so much of time.
No.
So give me also some time.
Of course.
Milord, I
That
shall.
you have not given. My time you have fixed. Now you will take most of the time. What will happen to me?
No, my lord, if required, we'll get an extension.
What will happen to me?
No, if required, we'll get an extension. We said that these issues, subsequent issues have arisen, which has taken a different turn.
My outer limit is fixed. Now you will be, both of you will be.
No, I think there's a
exhausting
word
most of the
preferable.
time.
No, Milord, I shall Milord try to be Milord as short and to the point, Milord, as possible. There is no point, Milord, because the issue is short. The interplay between Order 22 and Order 30, and most of the judgments are not Milord relevant to the case because the factual situations are different. I shall make my humble Milord effort before my Lord. Short. Milord, only thing, Milord, kindly recollect, Milord, I indicated my predicament before my Lord. That, Milord, until Monday, Milord, I am not in Calcutta. And this is, Milord, long decided program. Kindly do not, Milord, ask me to cancel it.
Personal or professional?
It is personal to the family.
Personal.
It is personal to the family. If it had it been my own personal, I could have sacrificed it.
আর ওটাই তো এক কথাই বলছেন তো ব্যক্তিগত
Yes, that is why I'm saying personal may not
Personal
be.
means
Personal
At
means
this
you
age,
are-
section 13 খুব embarrassing হবে.
জানে আর হবে না
বলে কোনো ডিফেন্স থাকবে না।
ওটা কোনো ডিফেন্স
Mr. Basu says that if you face section 13 at this stage, it will be embarrassing for you.
Decree will be a matter of course.
But kindly,
But there's a word in the Supreme Court order, preferably. I thought as much.
Preferably,
No, I'm saying
Mr. Bose,
preferably within a period of 3 months.
in 227, I was saying that as expeditiously, and I did not, in any of the order subject to correction, maybe by mistake, I used the word requesting, not directing. But even a request, yes, preferably.
Of course.
So that
Request
has
is
to
also a
be-
command.
Yes, that is to be taken into account.
Of course, of course, of course.
Desire of the
Thought preferably, if we disregard that, Mr. Bose,
No.
there is no use of using those expressions.
Absolutely.
Desire of the court is a mandate of
6th
the court.
October, November,
So it's
December,
that the Honorable Supreme Court expressed its desire that it is to be done within that time. So we have to try to obey to that.
Definitely. My Lord, we render all possible cooperation to my
Please,
Tuesday, minute.
Tuesday, all right.
CPM
Wednesday রাতে আমি Tuesday ফিরছি
ও
আমাকে
টিউসডে ফিরছিস তো
The
তুই তো
time-
এখানে মঙ্গল
My lord, I am returning on Tuesday, my lord. I may be able to join court late in the day. And tomorrow morning I am leaving. I have no time left with me, my lord, to even look at what Mr. Bose has submitted.
Third corridor, subject to your lordship's convenience.
Third,
As my lord, please.
325.
As my lord, please. I'm grateful.
We also observing 3:30 on that date.
No, the cause ends.
Instruction and Mr. Bose, Mr. Bose, not
follow.
Moinak Bose, Mr. Kollol Bose, maybe having better information.
Bolo.
Third, any 3:30.
ইভেন ইফ ইস টুডে ইজ অলসো 3:30
সেটাই তো জন্যই তো বলছে।
তাতে হোক তাতে কি এসে গেল
No, no.
জাজ ইজ নট বাউন্ড
Lord, we continue.
We'll continue.
We continue till the matter ends because my lord is in the midst of a matter. We can't ask my lord.
3:15 you will continue, you will complete.
We try. I'll try, my lord. As I assured my lord. My lord, I assured my lord.
3:25 is 1 hour you will be getting. You have said 1 hour. You will be getting 1 hour 5 minutes. 5 minutes for refreshing the earlier points and 1 hour.
As
the High Court has Millard celebrated his 150 years of Barclay Millard few years ago. Till date, Millard, this point, Millard, suddenly Millard, that this point is yet to be decided. How can he complete Millard this unanswered question?
That is why, because it's also a very interesting.
Yes,
It is.
That is why.
It is.
That is why your lordship normally on this civil matter, Millard, your lordship does not grant Millard so much of time, Millard, to the council. But that is why
My inability. Mr.
no, not inability, Millard. It is the
Is
quest
your
for
lordship's
knowledge.
ability.
It is Millard, your lordship's quest for knowledge. Still, that is why Millard we are enraged.
যেটা বলে থাকিস magnanimity.
But Mr. Chaturvedi, you have not found out any judgments on this point.
But I would.
No,
You
Millard,
have not searched out any judgments on
this
this.
point has
yes,
suddenly cropped up. Millard.
Yes,
We
yes,
did not anticipate Millard yesterday. Before yesterday, when the lordship, Mr. Chaturvedi was asking, because I have found I was talking to Mr. Chaturvedi, my senior friend, that there is a judgment Millard, which says the unregistered partnership from a registered party, it's not a juristic entity.
It is not a juristic
It
entity.
is not a juristic company.
Not a
65,
It
60.
is not a juristic entity.
Yes.
That is the judgment of Justice Sinha, SB Sinha.
Yes, so it's
Number-
well settled. It's
Yes.
not a juristic
Now, Millard,
entity,
Order
but
30 Rule 1, your lordship has made this specific.
by virtue of this provision. So
You can sue it in the name of the
by
firm.
virtue of this provision, you can sue the firm, provided it's a registered partnership. You can sue the firm, and Order 30 Rule 4, it's a non-obstante clause of Section 45 of the Contract Act. Whatever has been said there, even in spite of that, this will prevail.
Millard, I would
Because-
also request Ms. Learned senior friend to find out a decision to the extent, to effect, that what is the effect of non-obstante clause in a procedural law. It is not a subjective law, it is an adjective law.
You need not travel that far because 45 is a different thing
No,
altogether.
that is why, that is notwithstanding anything contained.
Yes, so notwithstanding, so it will prevail.
I will
It will
request
prevail.
my lord.
So if it prevails, now the effect, what is the effect of that? Because this is a very interesting provision. So one side is farm dissolves. If we take it at that, one side is farm dissolves. So the
cannot be
entity against
uncertainty.
whom you have instituted a proceeding, that is no longer existent, excepting the limited extent which Mr. Bose has pointed out in that decision. So let us for the moment says it's dissolved. But the statute says even in spite of that, suit will continue, no necessity to substitute. What is the effect of this?
One judgment.
Statute gives right, even in such a case, to proceed.
Otherwise, your lordship will see it will lead to inappropriate results.
That is why.
Illogical conclusions. I initiate a suit
Or
against
it
a
is
firm.
done. Many are
Resolved.
behind. So
This
there's
is
also a judgment on this, lifting that.
lifting
who are
the veil.
behind.
Corporate veil. Lifting of
In
corporate
same
veil.
pen,
Yes.
here also it has applied in partnership. Principle is the same. Principle is the same. Here it's not that the company is a separate legal entity, so it's not that. But here also it says yes,
জন্যই তো করেছে।
because only for that.
But Lord, on facts, Lord, we possibly are taking a lot many hypotheses then the admitted facts on record.
Now, yes, for that, Mr. Chaturvedi, you have to
Produce the deeds.
produce the deeds.
I shall.
So then, one thing, can you file a supplementary in the meantime, annexing the deeds, give a copy to them?
But I'll ask that if the deeds are available.
So you will be getting time. You
yes,
are
sir.
assisted by able assistance of Mr. Bose and Mr. Banerjee also.
My lord.
So let them file, because he has also to be, because he has to be given a chance.
Yes, yes.
Because otherwise he was not objecting, he was not insisting on filing of a supplementary affidavit. But I think it's better you bring it on
He
record
can file,
by
he
way
can
of a
file.
supplementary affidavit.
Absolutely.
Give
If
a
I
copy
get
to
the
them.
deeds, my lord, I shall file it. If not, then I shall rely on their admission where they say that the reconstitution has happened and these persons are being recognized as partners. I say once you recognize that them as partners and you say that the firm is continuing and
Right,
being,
admissions is there. So that is the difference.
need
If
I
you want
prove?
to bring those documents,
yes, still.
So if you want to bring those documents, then please file a supplementary affidavit. Give a copy to Mr. Bose well in advance.
Yes.
So that on third, he can come ready with the instructions or
My
other
lord,
things.
my lord.
Ashun. Mr. Bose learned. Standing.
Yes, yes, of course, of course, of course. Today, we we
Otherwise, it will be difficult.
assured the full cooperation from our side.
That Mr. Bose, I always get from the learned advocates. That's the
Absolutely.
cooperation. I must acknowledge that I'm always getting cooperation. Not for a moment I allege that I'm not getting cooperation from them.
We also get equal cooperation from the bench. Otherwise, it becomes difficult.
Cooperation, yes. All the
Absolutely.
learned advocates, they're in that cooperation. That I acknowledge.